All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning and welcome to the District of Columbia Court of Appeals in our virtual form. We have several special sittings on our calendar this morning. This panel is just here for the first case, and after this case, we'll take a brief recess. The YouTube feed will continue, but the panel will be completely reconstituted. So the first case on our calendar this morning is an emergency appeal. It is McDuffie versus the District of Columbia Board of Elections, 22 AA 276. My understanding is that we'll have argument from Mr. McDuffie, and then we'll have argument from the Board of Elections as well as intervener, and then we'll hear again from Mr. McDuffie. So counsel for Mr. McDuffie, would you introduce yourself for the record and let us know how much time you would like for rebuttal, understanding that we may keep you up at the podium for a little bit longer than the allotted 15 minutes.
Yes, good morning, Your Honors. Baruch Weiss from Arnold and Porter, representing Council Member KENYAN McDuffie, and I'd like to reserve 3 minutes for rebuttal, please.
Thank you. Whenever you're ready.
Thank you, Your Honors. May it please the court. We are here seeking a reversal of the determination made by the DC Board of Elections when it made a ruling that Mr. McDuffie is not eligible to run in the upcoming race as Attorney General. Mr. McDuffie's background, he is a member and has been for quite some time a member of the bar, state's attorney, DOJ attorney, and then 10 years a council member. And he clearly has or appears to have the qualifications that would be necessary to run for Attorney General, but the DC Board of Elections, nonetheless, based on a technical reading of the statute, determined that he was not eligible.
Mr. Weiss,
yes.
I'm sorry to interrupt you. First of all, if it's possible for you to move a little closer to the microphone, you're a little faint.
Yes.
But second of all, I guess the first question that we need to confront is what our standard of review is. And we have the parties arguing on the one hand that we should be interpreting the statute with a spirit of inclusivity as far as the candidates who should be allowed to run. And then on the other hand, that we should be deferential to the board. Could you speak to that?
Yes, Your Honor. We, of course, advocate that you should be looking at this with a presumption of inclusiveness and a presumption of eligibility. And we think that the deference that the other side has called for is not appropriate in this case. Deference is appropriate, as this court and the Supreme Court has held, when there is a gap or an ambiguity in the statute that is filled in by an agency that has the relevant experience. So, for example, if a statute says it is illegal to travel too fast on the streets of DC, and then there's a relevant agency with expertise and it makes a determination that faster than, say, 20 miles an hour is too fast, that is the sort of deference, the sort of determination that would get deference, because you have an agency with experience bringing that experience to bear where the statute leaves a gap. But here, both sides claim, although they differ in their conclusions, that the statute is unambiguous. Both sides claim that there is no gap. Both sides say that this is a simple legal determination, a legal reading of the statute, and the case law that we've cited for the court, primarily in our reply brief, makes crystal clear that when all that is being engaged in is an understanding of the statute, as opposed to, say, the hypothetical that I gave, where the agency is filling in a gap of the statute with its expertise, then the legal reading of the statute made by this court is to be done de novo.
And if we do it de novo, that's where I get a little bit confused about this spirit of inclusivity, because if we're looking at we're conducting de novo review without deference to the board, and we're looking at the plain language, which both parties say is clear.
Yes.
And is not ambiguous. Where does the spirit of inclusivity play in, because if the language is plain, then it's plain. And it seems like there's no room for injecting any spirit of inclusivity or exclusivity. The language says what it means and means what it says.
Yes, so let me answer that by as follows. If the court looks at the statute and finds the statute is utterly unambiguous, then you don't have to resort to the presumption of inclusivity. But if you listen to me and my argument and you say, well, he makes a lot of sense, and then you listen to Mr. Howard and Ms. Pembroke and you say, boy, they make a lot of sense. So while each one of us comes before you and says, in our view, the statute is unambiguous, and you're there shaking your head and saying, it's actually not so clear to us what the statute means, that is where the presumption of inclusivity would play a role. And
so if I could rephrase, you're saying our review is de novo, but if we find that the statute in fact is ambiguous, we should err on the side of allowing your client to
Yes.
be on the ballot.
That is correct.
Thank you.
Mr. Weiss, make sure I understand you correctly.
Yes.
So you are saying that if we find the statute ambiguous, we then resort first to the presumption of inclusivity before we go to the question of Chevron deference?
The rule of inclusivity, or the presumption of inclusivity, and the deference are not exactly the same. In other words, the Chevron deference plays a role where there is a gap that is filled by an agency that has experience in filling the gap.
Correct. I'm just asking which comes
Yes.
first.
Yes, I would say the presumption of inclusiveness comes first, because that would help. That is a canon of statutory construction. And that canon of statutory construction, like all the others, comes into play as you're trying to figure out what the statute means. While Chevron is a two-step process. And we don't think that you get to step one or step two until you've exhausted the canons of statutory construction and you've looked to what the statute means.
But to be clear, you don't think that Chevron deference applies at all,
Correct.
correct?
Correct.
Because you don't think that the Board of Elections has any particular expertise in this sort of statutory interpretation matter.
And they've conceded as much. I think they've said they're simply looking to the language of the statute. They did not say in their opinion that there was some gap or ambiguity in the statute where they had to bring their experience to bear. They simply looked at the words of the statute, interpreted the words of the statute incorrectly in our view, and therefore there is no agency expertise to which Chevron deference would be due in this case, both because it's mere statutory interpretation and because the agency didn't say that they were bringing their expertise to bear. They were
So let's move on to the language of the statute.
Yes, Your Honor.
As I read the statute in its current form, it has a residency requirement. It has bar membership requirements, two of them, right? A3 and A4. And then it has an experiential requirement in A5.
Correct. And that's the only one at issue. The first ones are not at issue.
Perhaps, although there might be some interaction. I mean, certainly the legislative history might suggest that there is interaction, right? So that'll take me actually to a question I have about the evolution of the statute. So initially in 2008, my understanding is the statute just had the residency and the bar membership requirements.
Mm-hmm.
And then the council got feedback from various community members saying you really should have an experiential requirement. This is an important job. This is a serious job. You need certain experiential qualifications. And so the council responded and added in its current form what is now A5. But it also, in at least the I'm going to get the names wrong, the engrossed original of the statute. So the version from January 5th, 2010, it had a different bar membership requirement. So it said, look, for most people, you need to be a member in good standing of the bar for at least 7 years prior to assuming this job.
Yes.
But we have an exception for law professors and for, and note this language because we see it again later, an attorney employed in the District of Columbia by the United States or the District of Columbia, right? Those people get an exception, right? If they've been employed in that capacity for at least 5 years and are just eligible for bar membership, they don't actually have to be bar members. We're going to give them a looser standard because it would seem, let me just finish my question.
Yes, I'm sorry.
Because we're giving them an exception on bar membership because of an experiential requirement, right? I guess my question is, when you see that language referring to an attorney employed in the District of Columbia by the United States or the District of Columbia in this version of the statute, do you think that the council was referring to anyone who's an attorney who happens to be also employed in the district by the District of Columbia, say, you know, the public school teacher example? They don't have to be bar members. They can just be eligible to be bar members because they are lawyers and they have a job with the District of Columbia. That seems a very odd reading of that language in that context. That
is not our reading of the statute or the bill. That was never enacted. If you look at that provision, and I have it right in front of me, you're right that it has an alternative to a history of bar membership in that bill. But there's one more phrase in that relevant paragraph that I think would be helpful in understanding what was contemplated by that bill at the time. It says, in the case of a professor of law in a law school in the District of Columbia, or of an attorney employed in the District of Columbia by the United States or the District of Columbia, has been employed in such capacity for at least 5 years.
Right. And what does in such capacity mean, right? And so my question to you is, do you think in that provision, they are saying the public school teacher who happens to be a lawyer and is employed by the District of Columbia? Or do you think when they say employed in such capacity and they're referring back to this language, which is precisely the language that we're going to be looking at later in A5, that they are saying, no, you actually have to have experience working as a lawyer for the District of Columbia, which seems to me the far more sensible reading of that language, given that they're giving people a pass on actual membership in the bar.
So I agree with you. I agree that in that bill, the language when it says has been employed in such capacity means that the attorney had to be employed in his or her capacity as an attorney. And I agree with you that a school teacher would not have gotten a pass under that bill. That language has been employed in such capacity is critical. And
why is that language? It's just referring back to the language that's at issue. I don't understand why that language would change anything. It's just a backward reference to the language that we're interested in. And so the language that we're interested in has to have a pre-existing meaning. And that's what I'm trying to get at. And it sounds like you're agreeing with me that the pre-existing meaning of the language that we're interested in is that that person has to be employed as an attorney by the district. And if it means that in that iteration of the statute, then I am curious to know why we think it means something else a month later when it's moved to what is now A5.
Let me address that. The relevant provision that you were looking at the bill talks about an attorney who was employed as an attorney and employed in such capacity for 5 years. There were two relevant changes that were made with respect to the actual legislation that was passed. First of all, the in such capacity, as I've pointed out, is no longer there. Moreover, when you
the whole exception is the whole experiential exception for government lawyers is erased.
Yes.
And now government lawyers have to be members of the bar in good standing for the same period of time as any other candidate.
But both sides agree that had our current statute said that you have to be employed as an attorney, had it said that, it does not say that in the current statute, but both sides agree had it said you have to be employed as an attorney, then there would be a requirement that the position that you occupy have as a prerequisite that you be an attorney. But the current statute doesn't say that. The current statute says you have to be engaged, not employed. And I want to talk about that very important difference in language. Engaged as an attorney, employed in DC by the federal or DC governments. Let me repeat that language because it's critical.
But you're just taking the same language that we just talked about that had a certain meaning before, and now you're giving it a new meaning because it's in a different place. And I'm trying to understand why, can you explain to me why, just by virtue of moving, it now has a new meaning?
It's not by virtue of moving, it's by virtue of the different word. The provision that you were talking about before that never made it to the ultimate statute does not use the word engaged. It uses—
Well, no, but I guess I'm not making my question clear, right? Now that this language that we've just talked about as having a meaning, right? An attorney employed in the District of Columbia by the United States or the District of Columbia. We just agreed that in the January 2010 version, that meant that you had to be employed as a lawyer by the district.
When
right?
it says employed, yes.
Right,
Employed
and it still says employed in A5D, but it is prefaced, hold on, it is prefaced by actively engaged, right? So we just decided that the language in D has a certain meaning. Now it's got this preface, and it seems to me you want to say that the preface changes the meaning of D, but I guess I'm trying to understand why that would be. It seems to me that the natural reading is to say, it's not just that you have to be employed, which is what we've already said that D, the language in D means. It means that you have to be employed plus, right? So, it means that you can't be on sabbatical or on, 2 years of maternity leave or, on extended sick leave. So it's employed plus you are actively engaged, because when you look at the other jobs in the list, right? A judge of the Court of the District of Columbia, we have a number of judges on our court who provide a valuable service to us in serving on our court as senior judges, but they do not have to work 365 days of the year. And many of them serve close to that. And for that, we are enormously grateful, but they're not obligated to, right? A professor of law at a law school can be employed by a law school, but can take a year sabbatical, or perhaps longer. I'm not familiar with the terms of those jobs, but they seem really nice. And so it seems to me that that's what that language is doing. And I don't understand the preface in 5 to alter the meaning in D that we agreed to.
So let me see if I can address that. There's quite a bit there, and I think I can address that. In the predecessor statute, with the language that didn't survive, it didn't simply say he was, the candidate was employed in the District of Columbia by the US or the DC government. It said he was employed in such capacity as an attorney.
Well, not employed in such capacity, it was employed in such capacity for 5 years.
Yes.
So the raison d'etre of that phrase is to give a time, not to change, as I understand it, the content of the initial phrase. The initial phrase has its own meaning. Or at least I thought that's what you and I agreed to moments ago.
No, I did
Or do
not.
you think we have to read the second phrase to give the first phrase doesn't have any meaning whatsoever? So
let me explain. There's a difference between saying employed versus employed as an attorney or employed in such capacity. I agree that when it said employed as an attorney or employed in the capacity as an attorney, there is a requirement that you be a member of the bar, and there's a job requirement going to the attorney element. In the prior statute, when it said you have to be employed in such capacity, it is the words in such capacity that not only gives life to the 5 years, but it makes clear that when you're employed, it has to be as an attorney. The current version of the statute jettisoned that language. Now, if the reading that you're suggesting now, engaged as an attorney, means employed as an attorney, then why would the statute say engaged as an attorney employed in DC? It changes verbiage in the middle. There's got to be a difference between engaged as and employed if the very same statute in the same sentence says you have to be engaged as an attorney employed by DC.
Well, I think I just gave you an example of a difference, but I've just cut off Judge Alitan, so I'll let her ask a question.
I think that we were probably going in the same direction. It seems like Judge Easterly is giving work to actively engage by saying you can't be on sabbatical, you can't be on disability leave, you can't be on leave without pay while still being employed. And so why isn't it a kind of plus factor that makes sure you're not just employed, but you are actively engaging in the job?
The plus factor that you're talking about is the word actively, but it could have said, if that's what meant, actively employed, rather than you employing, pardon the pun, a different word, engaged. When you have the word engaged and employed in the same sentence, to treat them as if they mean exactly the same thing is doing violence to the intent of the statute.
But if someone were on long-term disability leave,
yes,
they would still be employed, correct? But they would not be actively engaged in their position.
Correct.
So how is that giving the same meaning to the two words when they say very different things?
If it had said actively employed, it would have achieved the exact same thing, because that person would not be active. And there was no need to change the word from engaged to employed. There was no reason to use two different words in the same sentence and have them use the same and mean the same thing.
I think you're being a little bit too particular as to the vocabulary that is being used. I mean, I guess, I don't usually say I'm employed as a judge, right? Like, that's just not how, judges don't just apply to jobs and then get the jobs. You have to be nominated, you have to be confirmed. And so talking about people being employed as a judge, it's sort of an awkward construct. Employed as an attorney in the practice of law, if you have your own law firm, that might be sort of an awkward way of saying that you're employed. You don't have an employer, you are self-employed. So you can say that you work as a lawyer and you are actively engaged as a lawyer, but you aren't, a senior partner who is still on the letterhead, but, really only coming in for lunches,
This statute was modeled after the judge statute. The judge statute says employed as a lawyer. It could have, there was a change made when they used the judge statute as a template, which uses employed as a lawyer. And they shifted here. They shifted from the word employed to the word engaged. And
Mr. Wise, another difference between these AG statute and the judge statute, I'll call them for shorthand,
yes,
is that in addition to using the phrase employed as a lawyer, the judge statute requires an individual to be an active member of the bar, whereas the AG statute requires an individual to be a member in good standing of the bar, no
yes,
active.
yes.
What, if anything, do you read into that difference?
I don't know, Your Honor. I have to admit I didn't look at that difference because the bar membership here was not an issue. So I have to say I did not give that careful analysis. The only issue that was a dispute, or the only element was a dispute, was engaged as an attorney employed in DC. So
Well, I guess I'm suggesting to you that the omission of the word active there, but its appearance in 5, perhaps is some clue to us in interpreting what the statute means.
Well, I don't think you need that clue, because I think you also can take into account two other things that I think are a little bit clearer. One is that the first provision in the statute is enacted is that you are an attorney in the practice of law in DC. And if you were to interpret the attorney engaged as an attorney employed provision, which is D, the way that you're suggesting, the way that the Board of Elections suggested, the way that the challenger is suggesting, and the way that you're asking me about now, you really get to the same place. And there's really no distinction between 5A and 5D.
Why is that? Because I understand that the Board of Elections says, and it says in their brief and says in their order, look, essentially practice of law we understand to be the practice of providing legal advice or services where there's a client relationship, right?
Yes.
And there are a number of lawyers who work who are employed as lawyers for the District of Columbia, in the District of Columbia, who don't have clients.
Well,
Exhibit A would be the chief of our legal staff at the court, who helped us prepare for this argument today. And she is a lawyer. She is hired as a lawyer. She does not have clients, but she works for the court. So she would not fall under an attorney in the practice of law of the District of Columbia. She is not under Rule 49B2 providing professional legal advice to clients, but she is providing an inestimable service to this court as an attorney, and I think would clearly fall under D.
So,
Assuming, of course, that she's employed by the United States or the District of Columbia, and given
Well,
the
there's-
odd status
There's
of
the
our
rub.
court,
Yes,
we'll
yes.
never know the answer easily to that.
right. So the only example that they gave was the example of the hearing examiner, and hearing examiners are specifically defined in the DC statute as being non-attorneys.
Right, but what about my example?
Right. So in your example, I would.
And I don't think my example is unique. I think that there, and I'm sorry, Mr. Weiss, you just froze for a second, so I don't know if you
Yes,
heard
I'm
me.
sorry.
But what I was saying is I don't think my example is unique. I think that there are a number of lawyers who work in the district and a United States government who act in sort of attorney advisor roles where they are hired as attorneys and they do legal work as attorneys within the government, but do not have clients,
Right.
and are not in court necessarily, but are doing legal work and would fall under the Board of Elections interpretation of D.
So
yeah.
I would a number of responses to that. The first response would be that is simply not what the legislators intended when they passed this legislation. You have the amicus brief from the council members who tell you exactly what they meant. And this is not an isolated.
So there's another question, and I guess I'll divert, and then I'd like to get back to why we shouldn't be following Rule 49B too. But what is your authority for the proposition that we should be looking to a post hoc explanation by some group of legislators as to what they meant 12 years ago in legislation?
Well, there is, I mean, this is not some group, it's a significant majority. I mean, you're talking.
I understand
7 or
that
8.
that is, it is a significant collection of legislators, that the fact remains it is 12 years later. And I'm wondering, what authority do you have to point us to say that it would be a legitimate exercise of statutory construction to rely on their post hoc, not part of the legislative record explanation of what they meant when they said it in the statute?
So in candor, I'll confess that I would need to do some review to answer that question. If the court would like me to, we can file something within a day or so. Typically, of course, what you have is extensive legislative history that is contemporaneous. And typically, when you have something that's post hoc after the fact, it's usually in the case of, say, federal legislative history, it's an isolated congressman or congresswoman after the fact who says, this is what I intended at the time. And the courts typically don't give that much weight at all. But here you have something very unusual. You have a very significant majority of the people who passed this legislation who are saying this is what we meant. That is a very—
Okay, so at the current time, you don't have any authority to point to me that would say that it would be legitimate in our interpretation of the statute to look to that. Can we go back to why we shouldn't understand an attorney in the practice of law in the District of Columbia to align with our Rule 49B2?
There was no indication that they were looking at that particular rule when they were enacting this. The only thing that is even, I would say, more speculative than listening to what the legislators have to say about what they meant some 10 or 12.
Why is it speculative? I mean, why would they have to split out government lawyers at all?
Well,
If they didn't understand A to mean.
For a very simple reason, because there are many government employees who work in positions where they have to engage as lawyers, even though the position does not have as a prerequisite that you be a member of the bar. And what they were trying to do was they were trying to allow people who had accumulated significant public service in positions like on the council, where if you're an attorney, you're going to be bringing to bear your legal skills. They did not want to rule those people out. They didn't want to rule themselves out. Many of them were lawyers. They didn't want to exclude themselves from the possibility of running as Attorney General. What they contemplated was that there are many positions like that of council member, and that's one of many examples, where you need legal skills, even though a bar membership is not a prerequisite. And they said, if you're a lawyer and you use the legal skills that you have in a position that benefits from those legal skills while you're in government service, we want you to be able to run for Attorney General.
Well, I understand that that's what you think the statute says, but in particular in Mr. Spaiva's brief, he explains how the statute would be written if they had wanted to say what you're saying they meant to say. It's on page 30 of his brief.
Yes. Mm-hmm.
Can you explain to me why they didn't just say that, right? That they would have said, no person shall hold this position unless they're a member of good standing of the bar. And under 5, they would have had a new B, has been employed in the District of Columbia by the United States or the District of Columbia.
So
Wouldn't that just do what you're
yes,
saying?
that would be another way of doing it, but that's not the only way of doing it. When they passed this statute, they were aware of 2 ways of making the statute clear to make take the position that the DC Board of Elections took, and they rejected both. One was to say employed as a lawyer instead of engaged as a lawyer, and the other was to use the capacity language. They didn't use the employed as a lawyer, they used engaged as a lawyer. They didn't use the capacity language.
But it's not just that they didn't use that language, it's that they put government lawyers in the list with everyone else, right?
Yes.
And so it suggests that everyone should be treated the same. Everyone should have this experiential requirement.
Yes.
And that experiential requirement requires not just employment, but active engagement, right?
Yes.
Because I don't think you would be actively engaged as a judge without being first employed as a judge.
But
And then you have to be actively engaged, right? You wouldn't be actively engaged as a professor unless you were first employed and then not on sabbatical, actually teaching classes, publishing articles, right? The employment is baked in and is a critical predicate piece to the active engagement for A, B, and C. And you're saying it's not for D. And if they didn't want it to be part of the experiential requirements for D, they could have written it differently, and they chose not to do so. And that seems to be the strongest plain text clue that we have.
So I would respectfully disagree with that. What I would say is the word engaged focuses on what you do. The word employed focuses on the job. And what they're doing is they're taking the word engaged, which talks about your activity and what you do, and they're converting it into a job requirement when the statute doesn't read that way. And
so, Mr. Weiss, if I may jump in, it seems like that reading creates another different surplusage concern, which is why would we need B if under your theory, anyone who is employed as a judge is an attorney who's employed by the District of Columbia or the United States?
That would apply to their reading as well. That would, because a judge requires that you be a member of the bar. They've said that employed as engaged as an attorney means that there is a job requirement that you be a member of the bar. that you be an attorney.
No,
And
I don't think it would, right? Because we don't act as, I thought this was your argument. I thought your argument was that hearing examiners, ALJs, judges aren't acting as lawyers, right? And that's why we need B, to say, yes, you judges, as long as you are actually employed as a judge and actively engaged as a judge, you too could be the Attorney General of the District of Columbia, right?
yes,
We don't fall under D unless you're saying, well, it's not actually about the work that you're doing. You have the credential of a lawyer, you have a JD and a bar membership, and you are employed by the government.
but if you have a JD, and
So
you
it's
are-
only under your reading of D that B becomes surplusage, as Judge Alikhan just posited.
but then what do we do with hearing examiners? Then hearing examiners should have been listed with judge according to them, because hearing examiners are defined by statute as non-lawyers. So what I'm saying is that the problem that you're talking about is a problem under either reading, whether it's
I'm
our
not
reading.
sure I follow that, because being a council person also doesn't require you to be a lawyer. So for your view, it's, are you doing attorney-like things? And I imagine a hearing examiner who's opining on the law is drawing upon their legal expertise and experience in much the same way as you argue Mr. McDuffie is.
Sorry, Judge Alikhan, you froze for a moment and I didn't hear your question. I don't know if everybody else experienced that, but I didn't hear your question. Apologies. Could you repeat it?
Sure. So my question is, I would imagine hearing examiners, even though they're defined as not being lawyers, are drawing upon their legal experience when they are opining on cases, which is the same thing as you're alleging Mr. McDuffie is doing. And so I don't understand how the statute defines a particular class of hearing examiners would be dispositive.
Because the statute defines the word attorney, and it says attorney does not include hearing examiner. So I cannot include hearing examiner in any provision that uses the word attorney. I simply can't. But it does not exclude council members. So then I can resort to a common sense interpretation that says, is this person using the legal skills that he's accumulated as a lawyer in the work that he does as a council member? That seems to me to be a vast difference between a hearing examiner and a council member. The hearing examiner, if I were left to my own devices without the statutory definition, I would make the same argument, yes. But I have a statute that says a hearing examiner is not an attorney. In defining
Which statute are you referring to?
it is, we cited in a few places. We cited on page 30 of our brief footnote 10. That would be DC Code section 1-608.51 parens 2. And that section says that attorney means any position, blah, 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 except for any position that is occupied by a person whose duties in whole or in substantial part consist of hearing cases as an administrative law judge or as an administrative hearing officer. So for whatever reason, I don't begin to know why the word attorney.
This is from the merit personnel
Yes.
system. So this is not part of the statutory scheme that we are talking about. But you think that we should be looking at this definition? Do you have any authority to say that we should be looking at this definition?
Because I think they're talking about the qualifications, that whole chapter talks about the qualifications and supervision of attorneys. And here we're talking about the Attorney General. I think that, no, I don't have a case that says you should adopt that definition, but I do think it is informative. I do think
Your opening brief suggested that the board's interpretation and that of the intervener would make D surplusage. Do you still hold that view?
I do, Your Honor. I understand the questions that I've been asked by the court. I understand them very, very thoroughly, but I do think that somebody who serves, let's take an assistant U.S. attorney, that somebody who serves in a position that's clearly as an attorney, that's in the title, an assistant U.S. attorney, and has to be a member of the bar. Is that person practicing law in the District of Columbia? Yes, I think they are. And I think they fall within 5A. I think the example that you gave me of the attorney that is working or supporting the court would fit within 5A. I think we all understand that there are attorneys who have as their client the public. And there is nothing unusual about that. And I think that those attorneys, when they're engaged in a position that requires to be an attorney, are attorneys engaged in the practice of law, and they are in a position of representing the public. But the council member is in a different position because he's not an attorney in the practice of law, because there is no requirement that he be, there is no requirement that position be filled by somebody who is an attorney. And that is why we resort to the language consistent with what the members of the council said was the appropriate interpretation. He was engaged as an attorney and was employed by the District of Columbia.
And can I ask you a follow-up?
Sorry, go ahead.
The hazards of Zoom court. So it seems like you have two different potential strands of your theory. So one is the one that it seems like you focused on below, which is that as long as you are an attorney, then you fit under 5D. So that's the school teacher example, which in the transcript you said would qualify if you were a school teacher with a JD that was employed by DCPS.
Correct.
On appeal, you take, I think, a different tack, which is you have to be actively engaged by using your lawyer skills. And so you, I think, disavow in your brief the school teacher that has a JD. And I guess I'm wondering, do you see those as two distinct arguments? And if so, which one are you relying on today?
So let me correct something below. And when you say I was not counsel below, but my colleagues below took the position that both are interpretations. In other words, they took the school teacher interpretation, but also said in the alternative, they made the alternative argument that if there is a determination that there have to have been legal skills that were used in this position, that the council member qualifies. So we made both arguments below in the alternative. On appeal, we understand, and I understand, that the school teacher is a, shall we say, a harder argument to make and a less attractive argument to make. And so we are focusing primarily on the argument that he did serve as an attorney. He was engaged as an attorney because he used the legal skills which he had in order to do the work that he had to do in his position. Because after all, council members draft and analyze laws. That is part of the definition of what a lawyer does. Those who are not lawyers have to hire lawyers to help them do that. In this case, he did it himself. He also hired others, but he did it himself. And so I think that's the more straightforward argument. To put it another way, I'm having difficulty persuading you of the argument that I'm making. I think I'd have even more difficulty if I tried to persuade you of the school teacher argument. And I don't need to go that far.
I'm sure that's correct, because my concern with the argument that you're focusing on appeal is that becomes a very fact-bound determination. How often did someone have to draw upon their legal skills? Maybe the school teacher who teaches American government does need to draw on their lawyerly skills, whereas the school teacher who has a JD but teaches math doesn't. And so that becomes, to me, potentially very inadministrable. And so could you respond to that?
I understand that, and I agree that there can be difficult line drawing. I don't think this case is a difficult one for line drawing. And if this case is not a difficult one for line drawing, then especially in light of the presumption of eligibility, we should not disqualify this candidate because there may be a future case that will come up that will present us with difficult line drawing. We should let the people decide and the people vote in this case, because in this case, you have somebody who clearly is a lawyer in terms of his background, and he's clearly in a position that required him to use the legal skills, which he did. And that makes it relatively easier than the school teacher case, and that's why we're arguing that. Otherwise, you get into the paradoxical position of, let's say Mr. McDuffie hired a lawyer on his staff to help him or assist him review the legislation. That lawyer, because he was hired in a position that was required as a lawyer, would be able to run for attorney general. That subordinate would be able to run as an attorney general. But Mr. McDuffie, who hired him, supervised him, told him or her what to do, how to do it, reviewed it, wouldn't be able to, because Mr. McDuffie's
That
position
doesn't
doesn't
strike
have.
me as particularly odd, given that council members are not required to be attorneys, and a council member who is not an attorney would hire an attorney to assist them. And so that person would be eligible to run for AG, whereas the council member that does not practice law would not.
Yes, but that's because that council member essentially has to delegate his or her responsibility, not having the expertise, to the attorney.
But I think the point
Mr.
is that
McDuffie-
they're not required to have that expertise. If they opt to bring that expertise on board, that's fine. And then that person is operating in that role.
Sure.
I want to be mindful of the time. We've kept you up at the podium for a lot longer than the allocated time, but I think it's been time well spent. I think we'll turn now to the Board of Elections and hear from them. I think it would be helpful if the board could explain sort of the angle that they're going to approach the argument from, so that we know where to direct our questions to you and which questions we should reserve for intervener, if that's possible, for you to give us some signposts. And we'll move on from here. Thank you. You were muted, Ms. Pembroke.
Thank you, Judge Easterly. Good morning. My name's Christine Pembroke. I'm here on behalf of the Board of Elections, and we've agreed to split the time allocated by the court, 8 minutes for the BOE and 7 minutes for intervener. For my part, I think I'd like to focus on the standard of review, because that came up in the reply brief, and I think it's an area which the court may appreciate further argument from the board on. This case turns on the meaning of the statutory attorney general qualification language, which reads actively engaged as an attorney employed. On reply, Mr. McDuffie asserts that the standard of review supports his position that he is qualified under that language to be placed on the ballot. Mr. McDuffie is wrong. This court reviews issues of statutory interpretation as follows. First, if the intent of the legislature is clear, that's the end of the matter. For the court as well as the board must give effect to the unambiguously expressed intent of the legislature.
Ms. Pembroke, not to interrupt you, but what I understand Mr. McDuffie to be saying is, look, the court should review this de novo, and in interpreting the statute, one of the rules of statutory construction that it should be applying is that it should be examining the text with a spirit of inclusivity. I think there's been some language or some discussion of a presumption. I'm not sure where a presumption falls in this, and I'll get back to that maybe when Mr. McDuffie comes back up to the podium, but at least there's the language should be read with a spirit of inclusivity as we read the plain text de novo. Do you disagree with that?
Yes, I disagree with it on two levels. First of all, I don't think the standard of review is de novo. I think if the conclusion is made that the statute is ambiguous, this court should defer to the agency interpretation.
But what if we think that the plain language is clear, which both parties have argued that it is?
If the language is clear, then there's no reason to resort to aids of interpretation, such as a presumption in favor of ballot access.
So you don't think as we're examining the plain text and reading the plain text to see if we can discern an understanding of it, that this spirit of inclusivity should be part of our tools of statutory construction, much like we look at the words in the particular sentence, we look at the words in the context of the statute as a whole, right? You don't think that the spirit of inclusivity has any work to do here?
No, I don't believe. I think they're putting the cart before the horse. When you're looking at the plain language, you obviously look at the whole statute. You don't look at words in isolation, because that would be undermining the interpretation of the plain language. But then you don't look to legislative history if the statute is clear. You don't look to presumptions in favor of ballot access if the statute is clear. None of that.
I'm not sure that that's actually correct. I mean, if you read our decision in People's Drug, we say, we look to the plain text, but you might want to look beyond the plain text to the legislative history just to make sure that you're not missing any ambiguity in the statute, that there's not any sort of lurking absurdity or, way of interpreting the statute, that the plain language is leading to some sort of unjust interpretation. So I'm not sure that we're cut off from looking at these other sources as we read the plain text. I'm not sure that our case law supports that narrow view.
Well, even if you were to consider the policy in favor of ballot access, I don't think it shouldn't apply to overrule clear qualification requirements. So for example, there's a qualification requirement that US delegate candidates have 3 years of experience, 3 years of residency in the District of Columbia. The fact that someone challenges that shouldn't be a reason for letting them on the ballot if they've lived here for less than 3 years, based on the presumption in favor of ballot access. The qualification requirements are clear. If the qualification requirements are clear, those have to be honored. It's the only time, only when the qualifications are unclear should we be considering whether or not the presumption of ballot access would warrant giving the statute a more inclusive interpretation.
Well, your
And-
example of something that's clear is kind of contrary to what happened in the Lawrence case, because as you'll recall, it involved a residency requirement too. And it was Mayor Barry's time
Yes.
being incarcerated that made that question not so clear. So it's very difficult to find an element of the statute, this statute and similar ones, where there can be no ambiguity. But I take it that you think this statute is clear, that it is not ambiguous.
Yes, I think it's clear, and I think it's very different from the Lawrence case, because the Lawrence case involved what does the term being a resident mean? And as we all know, that term can have different meanings in different contexts. So there was a built-in ambiguity in that particular case as to the meaning of the term residency. But I think the statute.
Ms. Pembroke, could you clarify for me what you see 5D as requiring? And specifically, is it a position for which DC bar membership is required or just bar membership?
Well, I'm not sure I follow your honor's question. 5D talks about being actively engaged as an attorney. Are you saying that being an attorney implies some sort of bar membership? Is that where you're going?
Well, that's what the board seemed to suggest in, I think it's page 10 of the appendix, where they don't state what they think the requirement is. They parrot, I think, something from Spiva's reply before the board, which seems to say that it's DC bar membership, that is our position that requires DC bar membership is how you qualify under 5D. And the reason I ask that question is because many federal government attorney jobs do not require DC bar membership. They require that you be a member of a bar, but you need not be a member of the DC bar. Obviously, to run for attorney general, there are other provisions of this statute that require DC bar membership, but I guess I am wondering, what precisely is the board's view of what it means to be actively engaged as an attorney employed by the district or the United States?
I think the board's view would be that to be actively engaged as an attorney, you're in a position that requires some sort of bar credentials as a condition of employment. I don't think the board was necessarily trying to limit those credentials to DC bar credentials. And I think there are a lot of attorney positions that don't necessarily require DC bar membership. It may just be bar membership, particularly with the federal government. You can be employed and representing the federal government in federal courts and never be a DC bar member. And I think there may be some discussion of that in the legislative history, that, that there was an interest in making sure that those sorts of individuals were not disqualified from the office.
Why do you think that the board is correct in importing that language you just used, for which the job qualifications require bar membership? That's not exactly what you said, but close. Why do you think it's proper to import that into D when the comparable statute, which is the portion of the Home Rule Act that pertains to judges, uses the language employed as a lawyer, was out there as a model for the council to use if that's what they intended, and yet that language doesn't appear in the AG statute with which we're concerned? Seems to me that the strongest argument as to why the AG statute means something different is that there is a glaring omission of that language that appears in the judge statute, employed as a lawyer.
Well, I think that both statutes intended to cover the same class of individuals, and that although slightly different language was used, it doesn't mean that a different, necessarily a different intent.
Isn't it at least enough to create ambiguity?
I don't think that it creates ambiguity, because if you look at the context of the development of the statutes, it seems clear to me that both were intended to cover the same group of individuals. And I think it's interesting that, you know, even if it did create some ambiguity, that ambiguity doesn't necessarily lead to the logical conclusion that a non-attorney in the government should be qualified to be attorney general.
You mean someone not employed as an attorney, someone whose job did not require the attorney credential?
Right, right. Pointing to a difference in the language doesn't lead logically to saying, oh, that because the language is different, therefore Mr. McDuffie qualifies.
Well, I mean, that would not be enough to qualify, because the other provisions of the Attorney General statute include the requirement of membership in good standing in the bar. So we don't get to a non-attorney gets to be Attorney General.
In a non-attorney position.
Dispense with the requirement that being an employee of the District of Columbia or the United States is not enough, and one must also be employed as a lawyer. I mean, the membership in the bar requirement still excludes individuals who are not attorneys.
I understand, Your Honor, and just to be clear, when I say a non-attorney position, I'm referring to a position for which bar credentials are not a requirement of employment, as opposed to someone who's in a. Do you understand what I'm saying? I don't mean.
I think you may have omitted a word earlier, and that's why I was confused by your statement. But yes, I do. Let me ask you the question I asked before, which is about the one other difference between the statutes: the fact that the judge statute requires active membership in the DC bar in the relevant provision, and the AG statute requires membership in good standing without the word active. But of course, the word active shows up down in paragraph 5 that we're concerned with in the phrase actively engaged. Does that provide any insight, those differences?
I don't know that they necessarily provide any insight into whether or not someone on the council could qualify. I think that if anything, the OAG qualification language hints at the fact that somebody on the council would not be actively engaged as an attorney employed in the government, as contrasted with the judicial qualification of active bar membership. That is to say that the council went further with the OAG statute and required more than just mere active bar membership.
What does actively engaged mean in 5?
Well, there's certainly no discussion of it in the legislative history, but I think that Judge Easterly has correctly identified a logical meaning of that, and that means that you're working actively, carrying out the work as an attorney, not on sabbatical or not on some sort of leave or otherwise.
It doesn't just, it can't just mean employed then, because a professor who's on sabbatical is still employed in the law school. But I would agree with you that professor is not actively engaged. Well, I mean, I suppose even that's arguable. Somebody could argue that working on his latest book makes him actively engaged. I don't know, but it's at least questionable. Let's take an emeritus professor. An emeritus professor, I think, is sort of the clearest example of someone who has the title but is not actively engaged. Same for a retired judge who keeps the title but is not actively engaged. So actively engaged means what? It means doing legal work. Is that what it means?
I think it's a level of employment, a degree of employment that is perhaps not reflected by simply the term employed.
Ms. Pembroke, in what view, or in your view, who qualifies under 5D who would not otherwise qualify under 5A?
Certainly administrative law judges and hearing examiners. And I know that the petitioner has argued that those people are not attorneys in the government, but I think that's a misreading of the statute. The attorney provisions that the petitioner has referred to at DC Code 1-608 have to do with attorneys in the classification of the 0905 category, I believe, and they're just talking about, and that section just talks about the requirements for those types of attorneys. Administrative law judges, for example, are covered by DC Code 2-1831.08, which clearly requires that they have attorney credentials. I'm not sure where the statutory provisions are, if there are any for hearing examiners, but I would be very surprised if a job description for a hearing examiner did not include an attorney credential. But there's also individuals, as you indicated, Ms. Mason, staff counsel for the court, who might arguably not fall under that 0905 category and still also be an attorney employed by the government because her position requires attorney credentials. And there may be other examples that we haven't even been able to conceive because we haven't looked at the whole personnel system for the government.
So here's a question that I have in terms of what D might be doing, and this might be a half-baked thought, so push back if I'm wrong, but wouldn't it, let's say you are an attorney who is practicing at the SEC, but all of your work is investigating and litigating fraud cases in New York. So there you would not necessarily be an attorney in the practice of law in the District of Columbia under A, but you might be under D. Is that possibly correct?
It's possible. It's possible.
Ms. Pembroke, one of the board's concerns was about line drawing and the need to apply the statute on an ad hoc basis to individuals with varying levels of activity as lawyers. Hence the board's adoption of the must be employed as a lawyer or the job must require attorney credentials. My question for you is, why should the board be entitled to avoid such line drawing activities? Why? The board is one whose work frequently entails having to go line by line, for example, looking at nominating petitions to make determinations about whether signatures are from folks who qualify to have signed a petition. Its work is very fact intensive, resource intensive. The board certainly has the capacity in applying this statute to consider whether the work of a potential candidate consisted of being actively engaged as an attorney in the sense of applying legal skills and training. So why is that a basis for upholding the board's determination here? And in any event, why should our concern about that, if we have one, dictate how we come out in Mr. McDuffie's case, since no one seems to really dispute that in his job as a council member, he employed legal skills. We all understand that many council members are not lawyers or have not been lawyers, and no one is contending that it is a qualification for the job, but no one seems to doubt that if you have legal training, you will use it in that job, and unless it's shown otherwise. So again, my question is, why should we be concerned with that in this case, or why should we be concerned with it at all, given that this board is one whose job entails having to make ad hoc determinations of this sort based on the facts presented?
Well, I think that the fact that the board does have to make line drawing decisions isn't a reason to put us in the position of having to do that when it's not necessary. And that there has to be some deference to the board's interest in its understanding of being able to administer elections. And that in this particular case, the parameters of trying to ascertain who would qualify would be so vague that it would open the board up to all kinds of litigations every time it determined the attorney general qualifications for someone who was not in an attorney position in the government, and could result in, as we have here, emergency litigation going on at the last minute as the board is trying to finalize the ballot. This is the very situation that it's important for the board to be avoiding, and could have a devastating impact on our ability to move forward with holding an election. I mean, the petitioner in this case has asked for you to stay our order. That just is incredibly disruptive of the election process. And that's why I think the board felt so strongly about following a clear interpretation of the law, but an interpretation that also made its administration of the election laws possible.
So minding the time, because time is of the essence, I think we will move now, unless my colleagues have any other questions for the board, we will move now to hear from the intervener.
Thank you, Your Honor.
Thank you, Ms. Pembroke. If you could mute your mic for us, thanks.
Thank you, Your Honors, and may it please the court. I'm Ted Howard, Wiley Ryan LLP, representing the intervener Bruce Spiva. And subject to the court's questions, I would like to try to make several points, and I will try to be brief. The first is that the contention that our reading, that the interveners and the board's reading of Section A5D somehow renders Section A5A superfluous because there is no category of government employees actively engaged as attorneys who are not also, quote, actively engaged in the practice of law, is simply untrue. As we have expressly noted on page 27 in our brief, there are many categories of government lawyers whose work does not fit the definition of the practice of law as contemplated by Rule 49 of this court's rules.
What do you say, I'm sorry to interrupt you, but what do you say to the argument that that definition doesn't apply, doesn't seem to have been contemplated, shouldn't be imported into our analysis today?
I don't understand how that could be true, Your Honor, because Rule 49 effectively defines what the practice of law is in the District of Columbia as regards members of the District of Columbia Bar. I don't know why that definition would be ignored. It clearly is applicable to the way in which folks who have law licenses and who are licensed to practice in DC are perceived in terms of what they do and how they do it.
So essentially, because this court oversees the bar and it wrote the rule, it is controlling.
We believe so, yes, Your Honor. In any event, as we noted in our brief, there are investigators, there are auditors, there are mediators, there are hearing examiners and administrative law judges, all of whom we believe are eligible to run for Attorney General. Not because they're engaged in the practice of law as defined by Rule 49, but because they fit within the definition of actively engaged as attorneys employed by the government. Mr. McDuffie says in his reply brief that a person is actively engaged as an attorney employed by the district, and I'm quoting, when they are an attorney, they are employed by the district, and their role as a district employee routinely involves the use of legal skill or judgment. 2 points about that. First is that it totally abandons the position that they affirmatively argued before the board, which is that a teacher employed by DCPS, who also happens to have a law degree and has maintained active bar membership, is eligible as Mr. McDuffie would be to run for Attorney General.
And I guess, Mr. Howard, what's wrong with that as a policy matter? So in the school teacher example, the Office of the Attorney General has a lot of cases where the public schools and the charter schools are clients. Maybe the electorate would like someone who has legal experience and a law degree, but has focused on being a school teacher or being a garbage collector or having some other public service job that gives them a wide vantage of how to run the district's public law firm.
But the teacher is not actively engaged as an attorney, and that's what A5D requires. So even though, and it really sort of, I think, spills over into the question Judge Thompson asked with respect to line drawing or ad hoc determinations that the board finds itself in a position of having to make in other contexts. Trying to determine whether or not a particular person in a non-attorney position, quote, routinely does their job in a way that, quote, routinely involves legal skill or judgment would require the board and the court in reviewing the board to make the kinds of determinations that in many instances would require an evidentiary proceeding and fact-finding, because who's to say that a teacher who teaches American government, who also has a law degree and has maintained active bar membership, isn't routinely engaged in applying their legal skills and judgment.
Well, until the
the
parties
only-
in this case stipulated that there was no need for an evidentiary hearing, the board certainly contemplated holding one. What's wrong with that? Wouldn't have to be a month-long hearing. You put the school teacher on the stand and you have her say what in her work involves actively using her legal skills, and the board makes a determination. I mean, why is that a reason to rule the way that you want us to rule in this case? Doesn't seem not doable. And as I said, the board routinely has to spend time looking at minute things in great detail in order to determine who gets on the ballot.
Well, because with respect, Judge Thompson, the statute, and particularly section A5D, is set up in a way as to impose or apply objective standards to determine who's eligible. And reading the statute in a way that requires an ad hoc determination in every instance as to whether or not someone is actively engaged as an attorney, irrespective of the fact that they're not in an attorney position in the government, means that D applies in a way totally different than A, B, and C of that statutory provision apply.
Well,
and
why
that,
is that?
And that is
You might
inconsistent.
have a professor who has spent several years on an extended sabbatical or on sick leave or some combination. And someone might step forward and challenge the professor's eligibility to run for attorney general. And then there could be a hearing about whether or not the professor's work during the years in question constituted active engagement as a professor. Seems to me it could be necessary in that case as well. And our imaginations may not enable us to perfectly find the examples of that, but I doubt it's correct that only in D do we run into the issue.
Well, I think when the remaining eligibility requirements in the statute are combined with the elements of D, you largely avoid the problem that you just described. Because if a person is a member of the bar and has been in active status, or sorry, I'm drawing a blank on the exact words, but you know what I'm getting at in terms of their position as a member of the bar, plus actively engaged as an attorney. If it's read in the way that we believe that it clearly is meant to be read, then it's a clean analysis and a clean determination, and one that does not require fact-finding or subjective judgments as to who is more or less the functional equivalent of someone who's actively engaged as an attorney.
Let me ask you this question too. And by the way, can I also ask you, how does your client pronounce his name?
It's Spiva, Your Honor.
Spiva, thank you very much.
Yes,
So one of Mr. Spiva's arguments, something he emphasizes, is the council's efforts to make sure that candidates for attorney general have the experiential qualifications for the job. And clearly they did turn to that when they moved away from the original bill, and they added some language that goes to experience. But as one of the briefs points out, they only went so far. And I believe the example in the brief was that someone might be a professor of international law, a worthy subject to be sure, but not one that immediately suggests the relevant experience to be the Attorney General of the District of Columbia, worrying about such things as slumlords and consumer protection and all of the many things the Attorney General must worry about. So why should we read 5D in such a way that it demands more experience than the language itself requires? I mean, why isn't it a voter issue to determine whether Mr. McDuffie or the school teacher or anyone else brings the relevant experience to be Attorney General?
Judge Thompson, I would say this. The imposition of minimum requirements for eligibility is characteristic of the federal government and state and local governments around the country. A candidate, a prospective or putative candidate for President of the United States who is brilliant and capable and empathetic, and all of the things that we might wish to see in a candidate who happens to be 34 years and 6 months isn't qualified to run for president. They're not eligible, irrespective of all of those other qualities that they have that might make them attractive as a candidate. So here, the minimum eligibility requirements are what they are. If you're in the pool, then the question becomes for the electorate whether or not the professor who happens to teach international law or law of the sea or admiralty or something like that is well suited to be the next Attorney General of the District of Columbia is entirely fair game for the voters to consider. But that doesn't mean that if that person otherwise doesn't meet the eligibility requirements, that we just throw open the pool to whoever and say, let the voters decide. That's not the concept of this statute. This statute—
Well, to be sure, we have to adhere to the statutory language. And so let me ask you the same question I asked Ms. Pembroke. Seems to me the best argument for why we should not interpret the AG statute in the way the board did and the way you do is the difference between its language and the language of the judge statute, the one that says that to be appointed a judge, someone must have been employed as a lawyer, among other ways that one can qualify, employed as a lawyer by the United States or the District of Columbia. That language was out there to be used. It would have made the legislative drafting a lot easier. And yet, the council just refers to actively engaged as an attorney employed in the District of Columbia. I mean, why shouldn't we conclude that the language, the plain language, does not require employment as a lawyer by the district or the United States?
I think that your contention, with due respect, Judge Thompson, is premised upon an assumption that there is a meaningful difference in the language as between actively engaged as an attorney and employed in the capacity of an attorney. And there's no indication in the contemporaneous actual legislative history, as opposed to the post hoc explanation in the amicus brief, that the council wasn't using those terms interchangeably and in a way that they understood essentially meant the same thing.
Mr. Howard, can you please speak to what role you think the, I don't know if we're calling it a presumption or a canon of construction, but the Lawrence principle plays in terms of reading the statute in terms of finding things to be inclusive? And then secondly, whether you think there is a role for deference to the board here or whether our review is de novo.
As to the presumption of inclusivity, I agree with the premise, at least the underlying premise. I'm not saying that she endorses this view, but the underlying premise of Judge Easterly's questions to Mr. Weiss, that the presumption of exclusivity has no role so long as the statutory language being interpreted is clear and unambiguous. And that is clearly our view. And it is clearly our view that this is a question of law. And it is our position that the board read the statutory language and interpreted it correctly. And therefore, to defer or not to defer, we believe doesn't really come into play. The decision of the board should be affirmed because it was correct, irrespective of deference.
All right. Unless my colleagues have any other questions for Mr. McDuffie or for Mr. Howard on behalf of Mr. McDuffie, I think we will now hear—
Mr. Spiva, Your Honor, sorry.
I'm so sorry, Mr. Spiva. We will now hear again from Mr. Weiss in rebuttal, and we'll give you a few minutes to wrap up.
Thank you, Your Honors.
You are muted.
Yes, I'm sorry.
That's all right.
A number of points I need to address. One is, if I may call it the Miss Mason argument by way of shorthand, and that is whether 5D comes to cover the Miss Masons of the world in the examples that you gave. And I think that there's no need for 5D to cover the Miss Masons of the world. And I said that before, but I want to say it a little bit more succinctly. Let's say the Miss Mason, and of course I'm using her just as an example, is filling out her next bar application or reapplication. And she's asked the simple question, have you been an attorney in the practice of law in the District of Columbia over the past year or 2 years, whatever the period is covered? Or if an assistant U.S. attorney in DC is asked, have you been an attorney in the practice of law in DC for the past year? Nobody is going to say to them, you should not check yes to that box. They would check yes to that box very comfortably. They would say, and they would say under oath as they reaffirm their right to continuing bar membership or their application for continuing bar membership, that I am an attorney in the practice of law in DC. I think we're going through
Mr. Weiss, if I could interrupt, what about the SEC attorney whose sole practice is investigating matters in the Southern District of New York and is a Florida bar member?
All right. Well, if that, so first I would say to you, I would, with all respect, say that I do not think there's any hint whatsoever that the council in enacting provision 5D was thinking of a case like that. Yes, we're all stretching to find what does 5D cover that 5A does not, but these council members weren't, there's nothing to say that they were thinking of somebody located in DC, a member of the Florida bar, investigating in the Southern District of New York.
To be sure that is true, but the issue here is that the legislative act is line drawing. And one hopes that in line drawing, the legislators think in broad strokes about who is in the box and who's outside the box. I don't know that we anticipate that the legislatures will think of every single example. And that's where the courts come in, right? To draw the line a little bit more finely if it is not, if people are unclear as to where the legislative line has been drawn. And looking to post hoc explanations is not really helpful for courts. We're supposed to be looking at the line. And it seems to me that the example that Judge Ali Khan proposes falls very comfortably under 5D. And so your answer, oh, they just weren't thinking about that. I'm just not sure why that is helpful to us in deciding what we're trying to decide. And so I wonder if you could take your answer in a different direction.
Yes. Well, I think it's much more sensible to say that they were thinking of themselves. Did the members of
Is there any evidence in the record that that is true?
But there's no evidence that they were thinking about an SEC with Florida bar membership in New York.
Precisely.
Evidence of what I think they might have been thinking of. We keep talking about the judge statute, which is from the charter, and that is binding, but there's a separate judge qualification statute in Title 11. It's 11-1501B2, and that language seems to be quite similar to the AG statute language. And so
I believe that was superseded by once the charter took this language in. So I think this is
absolutely. It is not controlling, but it's still on the books. It's still, if you open your code book, it's there.
Yes.
And you could imagine someone being perhaps perplexed by the fact there are two judge qualification statutes that actually say
I was, yes.
But what's to say that the council knowingly or unknowingly opened up to Title 11 rather than Title 2 and copied that language? And that language, I think, could be read, especially because it comes from, I believe, 1970, at a time when the district government was mostly federal right? To want to make sure they're casting a wide net to make sure the folks like the SEC attorneys or the USDA attorneys or whomever would be eligible in that case to be judges. But then by importing that language into the AG statute, we're also giving effect to 5D, not with hearing examiners, but with a large swath of federal government attorneys who might not practice specifically in DC.
Well, all I could say is I think that it makes more sense if we have to assume that the council was using the operative language as the template rather than the superseded language as the template. And the issue here is, were they aware of the language that says employed as a lawyer? Were they aware of the language that says employed in such capacity? And I think they were, and they didn't use it. And so as I made the original argument, I think that when they they decided to utilize language that says engaged as an attorney, without saying that he's employed as an attorney, without saying that it was in such capacity, I think the simple reading is you look at what he was in, or she was engaged in. I'm using he because we're talking about Mr. McDuffie. What he was engaged in, and he was engaged in drafting legislation and analyzing legislation. That falls within the definition of what attorneys do. And therefore, we think that the language covers him. And another argument I want to address for a moment is the line.
But does that mean that activity who are not barred are engaged in the unauthorized practice of law? And I don't think that you would make that argument.
I would not, because this provision doesn't say you have to be engaged in the practice of law. That's A. This just says you have to be engaged as an attorney.
I'll give you a couple of minutes. And if you just want to wrap up, we are well over time, but
Yes.
I hope that you've made all your points. And if you haven't, please go ahead and do that now.
I have one last point that I'll make quickly, which is this. I'd like to talk about the line drawing for a moment. And I think it was Mr. Howard who made the argument that there should be no line drawing, no need to draw lines, and then engaged. I think there was a discussion with Judge Thompson about professor. I'd like to point out that there's a huge amount of line drawing that has to be done for a professor. What if you have tenure? What if you don't have tenure? When I was in AUSA, I was a lecturer at a law school. What if you're a part-time? What if you're an associate professor? There's a great deal of line drawing that needs to be done. And so there's no reason all of a sudden when we say an attorney employed to say, oh, now we're afraid of line drawing, when it's inherent in really all the work that the board, or a lot of the work that the board has to do. The last point I want to make is actually a question for the court, and that is, are we authorized to submit something tomorrow on the question of the post hoc amicus brief and its relevance? We did not address that in the brief. It seems to be an important issue to the case. We would take one day to address it.
I think that the time for you to provide that authority was with the initial briefing. If you would like to try to provide us with that authority in short order, we will accept it if it is before the time that we've made a decision. We are cognizant of the time restrictions, and we are going to try to proceed to a decision as quickly as possible without committing us to any particular schedule, but that is our aim.
Well, then we will submit something by this evening. We will submit something by this evening, and I hope that works with the schedule.
Thank you very much, Council. We really appreciate your presence here today to sort through this important matter. We appreciate the briefing that we received on a very tight schedule. This case will be submitted. This panel is going to leave the bench, and the panel will be reconstituted for the next arguments. And our apologies to the attorneys who are waiting for their cases to be argued later this morning. So thank you very much, and counsel are dismissed from the courtroom.
Thank you.
This court will take a short recess to prepare for the next argument. This honorable court is back in session. Please come to order.
Hello, everybody, and welcome to the DC Court of Appeals, or welcome back as the case may be. Thank you all so much for your patience in this panel juggling we're doing this morning. The next case that we will be addressing this morning is number 19 CV 1161, DC Metropolitan Police Department versus DC Public Employee Relations Board. Whenever you're ready, counsel.
Good morning. May it please the court, Carl Schifferle for the appellant, Metropolitan Police Department. I would like to reserve 3 minutes for rebuttal, if I may.
Yes.
For purposes of Section 51031's tolling provision, the criminal investigation of Mr. Lopez did not conclude until the dismissal of the criminal charge against him. This is evident from the language of the tolling provision, as well as its manifest purpose to avoid parallel criminal and disciplinary proceedings, which would be in no one's interest, especially those of the employee. The arbitrator's opposite interpretation that a criminal investigation would presumptively conclude as soon as criminal charges are brought would defeat this legislative purpose and is contrary to Section 51031. PERB and FOP's attempts to insulate this award from any meaningful review would make this statute entirely unworkable in practice, since MPD would never know in real time when the statute's 90-day clock is actually running. And so by disallowing disciplinary charges that were timely brought under Section 51031, the award was contrary to law and must be set aside.
Mr. Schifferle, maybe that's the nature of this odd procedural setting. Our cases, in somewhat confusing way, say that, you know, the parties bargain for the judgment of the arbitrator, be it right or wrong. So how can you overcome those cases?
Because the parties did not and cannot bargain for the arbitrator's interpretation of Section 51031 that would be contrary to law, or in a sense result in any deference to the arbitrator. There are several reasons for this. First of all, this does not involve sort of factual findings by an arbitrator. We have a given set of undisputed facts, and the question is application of those facts to the statute, and that is a question of law, as this court explained in Sunbelt Beverage, as the Supreme Court recently explained in Guerrero Las Barrias, that where you have a given set of facts, whether those facts satisfy a statutory or administrative deadline is a question of law. And furthermore, where we have a controlling statute, I don't think any of the case law from this court addresses the situation of a controlling statute like Section 51031 in this case.
To some extent, we're then in a time warp. If we had not definitively interpreted that statute at the time of the arbitrator's ruling, how could it at that time be contrary to law?
Because it is a question of law that this court would analyze or should be analyzed in the normal course. That is, determining whether the statute is unambiguous in the first instance by looking to the language of the statute, its manifest purpose here, precedent, canons of construction. And in doing so, we submit, and I can get into those reasons, that the statute therefore is unambiguous in this particular situation. There is
do you think it's permissible for us to sort of act retroactively? In this case, at this time, declare what the law means, and then say that unbeknown to the arbitrator some years ago, what he said then was contrary to law?
If it is simply a question of what the law means, both then and now. The only proper interpretation, the correct interpretation of Section 51031 is that the disciplinary charges in this case were timely brought. And by establishing that being the case, the award is necessarily contrary to law. Again, the parties could not have bargained for an award that would be contrary to law. The CMPA expressly directs PERB to address whether an award and reviewing an award is contrary to law. And as I said, if it is involved, certainly whereas here, a controlling statute, where the basis for the arbitrator's decision is Section 51031, and Section 51031 affirmatively authorizes the department to bring these disciplinary charges within the time frame that is allowed here, and yet the arbitrator's award prohibits precisely what the statute authorizes, then it is contrary to law. And I did want to get into the reasons why that is so. In dismissing the criminal charge, the prosecutor necessarily reviewed the circumstances surrounding the alleged crime, including Mr. Lopez's efforts at rehabilitation, and as shown by the proof of completion of the diversion program that Mr. Lopez submitted, and the prosecutor made the decision that continued pursuit of the charges was not warranted. That's consistent with the Jordan case, where this court held that at a minimum, a criminal investigation continues if the prosecutor is reviewing evidence and making the decision whether to pursue charges. That's consistent with the broad definition of criminal investigation that this court has used and referenced, including most recently in the Butler case, that a criminal investigation is, quote, a comprehensive effort to better understand the circumstances surrounding an incident. It provides the clear and predictable guidepost, which is necessary when interpreting and applying a statute of limitations. A statute of limitations like this simply cannot function.
Mr. Schifferle, I mean, it's a compelling point. But about a year ago, and I'll forgive you if you don't recall it, there's a case called Evans, where you were taking the opposite position. In Evans, the argument was about whether or not dismissal of an indictment, dismissal of the charges, marked the end of an investigation, or whether a subsequent declination letter that came about a couple months later was really the end of the investigation. Here, it sounds like your position is when charges are dismissed, fair inference that the investigation has concluded. Is that your position?
Yes, and there is a distinction, obviously, between the Evans case and this case. In Evans, the case, the indictment was dismissed without prejudice. There was a clear indication there that the prosecutor was continuing to evaluate whether to pursue charges. And in fact, the letter of declination itself was evidence that the prosecutor was doing so. And in fact, I believe was considering potentially other charges as referenced in the letter of declination.
I mean, we might disagree about that. But what about the dismissal of these charges? Why do you think that this is open? You know, that means that it's over. Could these not be brought again? Could they not reinitiate the charges?
Well, this case is different because it did involve this agreement, this involving the diversion program. And so by the criminal defendant's completion of that diversion program, presenting proof of that completion, the prosecutor then looking at that evidence and making the decision that the agreement has been complied with, and then dismissing on that basis, that certainly does suggest that those charges will not be brought again.
I mean, the reason I'm pressing on it is that you said, you know, there needs to be a clear guidepost. And as you sort of take a very slightly different facts, the guidepost doesn't seem that clear. If you were coming before us and saying the dismissal of charges that's the guidepost, that's when the MPD, you know, if charges are brought, that's when the 90 days begins to run. That to me is a coherent position that provides a clear guidepost and could make some sense of things. But it doesn't sound like you're advancing that. Instead, it sounds like, you know, whenever it works out for you, you want that guidepost. But if there's a dismissal of charges, you can always extend the 90-day period by doing something else after the dismissal of charges. File a declination letter 60 days later, and that will re-trigger the 90 days. So I just don't get the sense that it's that clear of a guidepost to you.
I think it is, because if the dismissal reflects that the prosecutor is continuing to investigate the case and that charges, you know, there's some realistic possibility that charges will be brought again, that's different from a scenario, whereas here, there's no such suggestion that the prosecutor would be bringing charges in the future. And it's important to emphasize here that it has to be understood in the context.
In a scenario where charges are dismissed without prejudice, and then nothing else happens on the charging side of things, when do the 90 days begin to run?
So it would run from that dismissal. Again, I'm assuming there is no further criminal investigation that would result in a declination letter if there were. So if there's a dismissal and there's no declination letter, then that would be the end of it. I did want to get to the point, though, that it's important to interpret this provision in the context of its purpose. The tolling provision's purpose is to prevent parallel criminal.
Mr. Schifferle, if you'll forgive me, we've read your briefs and you talked about the purpose eloquently. Has PERB ever ruled definitively on the legal position that you're advancing to us today? And I understand that to be that while criminal charges are pending, as a matter of law, a criminal investigation is in progress.
PERB has not directly ruled on that point. The Superior Court has. We cited a number of cases, most recently the Michael Minor case in our 28.
In this odd setting, we don't care what the Superior Court says. And I guess my ultimate question is, should we get a definitive ruling from PERB before we set out to construe the statute?
I don't think it is necessary to do so. I reference the Superior Court decisions also to mention the fact that they arise from OEA decisions. So the Office of Employee Appeals is also responsible for reviewing 90-day rule issues. And so I don't think PERB for that reason should be getting deference. In fact, in the Butler case, this court suggested that OEA would be getting deference or presumed that it would be doing so. So
even if you say it's not necessary, wouldn't it be a good idea for us to know what PERB thinks on this question, even if we ultimately don't end up deferring to them?
I wouldn't want to deny the court that benefit. I don't think it would serve a purpose, since I think the conclusion
it would be irrelevant.
Yes, I mean, it's our position that PERB's determination would not be entitled to deference, so it wouldn't have legal relevance. We would submit. With respect to Judge Fisher's question, I did want to point to two PERB cases, although they did not involve when a criminal investigation concluded. They did involve PERB reversing an arbitrator's 90-day ruling. That was the Glover case, which we discussed in our briefing, and then the Turner case, which we just provided to the court in a Rule 28K letter. And in both of those cases, PERB did not apparently defer at all to the arbitrator's legal conclusion about when the 90-day rule had been told. It made its own determination. We submit de novo.
Didn't the PERB defer in our case, the present case, to the arbitrator's ruling?
Well, I would say it's certainly not the type of deference that PERB is now asserting on appeal. I think we satisfy, to the extent that it does suggest, the decision in this case does suggest any deference.
Help me with this. Our cases suggest, and I'm not sure I understand why, but our cases suggest that we review rulings from OEA differently than we review rulings from PERB. Do you agree with that?
I do not. I don't know if the court is suggesting that perhaps PERB gets some sort of heightened deference above the type of deference that an agency would ordinarily receive.
Our cases seem to say that, and I think particularly of this catchy phrase, rationally indefensible.
Yes, that's a phrase that was used for review of factual findings. Certainly not, as here, a question of law. I think PERB has, and Mr. Simpson can correct me if I'm wrong, but I think PERB would concede that it is not entitled to some level of deference that is above and beyond the deference that is normally accorded any agency.
Can I just press you on why you think this is a legal conclusion? I mean, the core of the arbitrator's ruling, which PERB then cites in upholding it, is, to quote, this is at page 10, the record does not contain evidence, nor did the MPD offer any, that the investigation continued beyond that date being the bringing of charges. That sounds like a factual conclusion about the state of the record. We just don't have any evidence that anything happened after bringing charges. And so why do you think that's a legal determination as opposed to a fact? I take it you don't, I mean, you do contest the factual statement that there was no evidence. You say that there was evidence. Okay, but that sounds like a factual dispute to me. Am I wrong?
No, because it's not a dispute about whether certain facts exist or not, or whether there's a dispute even about what facts exist. It's simply take the given set of facts, which MPD is not contesting. Follows from that as a matter of law that there was a criminal investigation. And in part, we're relying upon the
So can I ask, just as hypothetically, let's say charges were filed in a case in 1995. Nothing happened. And then 25 years later in 2020, there is this, a disciplinary action is brought based on those. And the facts on the ground are, look, we brought charges, and honestly, we just forgot about him. The guy who brought the charges, the prosecutor in charge of that case, he left the office. He was checked out. These things have just stayed pending for 25 years. You think as a matter of law, the investigation continued those 25 years?
Well, I would have to answer in light of the purpose of the tolling provision, which I can get into. So I would say yes, but what the court is positing does not seem like a concern for the court. That is, once criminal charges are brought, you have an adversarial proceeding. Someone is there for the defendant to insist that the charges be prosecuted. You have a judge who's overseeing.
I don't know if a defendant has that interest. If everybody else has forgotten about the case, you might want to keep your mouth shut.
There's also a judge who oversees the case and manages his or her docket. You have statutes and rules of procedure that are designed so the cases move along expeditiously.
Right. I mean, so it's a fanciful hypothetical. I mean, it's meant to be, but your answer is yes. Even then, even though I think you'd agree with me that one of the purposes of the 90-day rule is to give the grievance some finality, so they're not, pending in limbo forever, so that 25 years later, you don't get a grievance, a disciplinary action initiated against you. It wouldn't seem to serve that purpose.
Right, I do recognize that purpose, but here we're talking about the tolling provision and the manifest purpose of the tolling provision, which is to avoid that very prospect of parallel criminal and disciplinary proceedings. And there are important reasons why that is so, and important reasons for the employee.
Let me ask you a related hypothetical. Let's assume that a police officer is charged with a really serious crime like murder. And we know that it sometimes takes 2 or 3 years for such cases to be tried. Do you think that the tolling would literally apply until that case is finally tried?
Yes, it would. And again, that's the purpose of the tolling provision. The officer, if the disciplinary investigation proceeds, the department can interview the officer, and the officer then would face the choice of giving answers, which then could be used against the officer in the criminal case, or remaining silent, but then the silence can be used against the officer in the disciplinary proceeding. So it's a lose-lose situation for the officer with respect to his Fifth Amendment interest. And there's the broader interest of the officer. And once the disciplinary proceeding begins and the officer has to make additional statements, present evidence, present its strategy, tip its hand as to how it's defending, that is all to the detriment of the officer in defending against the criminal case. And then, serious criminal charges, in Your Honor's hypotheticals, the employee's interest is
You brought to our attention the minor case, I believe is the name of it, that came from Judge Pan. In that case, the government won because there was an affidavit from the AUSA that said that even though an arrest had occurred, and under the ruling from Arbitrator Kaplan, that meant the investigation was over. I, in fact, was investigating after the arrest, and so MPD won. Why can't you simply do that in other cases?
I don't think that would be a good practice to demand that the prosecutors, in all of these cases come in and testify as to their thought processes and what they were doing and what they were investigating. That sounds like a very inadvisable practice to me. And again, it doesn't establish the bright line that would be necessary for this sort of statute to be workable and work in the way that the council intended in providing clear guideposts. Again, it becomes an after the fact determination of what the prosecutor,
Well,
what evidence.
Your rule doesn't establish a bright line for all purposes either. You're probably familiar with what we call a grand jury original, where no arrest occurs until an indictment has been returned by the grand jury. I take it you'd argue that there was a criminal investigation going on, even though there were no charges pending. Also, it's not uncommon for somebody to be arrested and for the charges to be dismissed at that point because the evidence isn't strong and the prosecutor continues to investigate. So the pendency of a case would not answer your request for a bright line rule. So in many instances, you'd need supplemental evidence to prove that an investigation was ongoing.
No, we would submit that in the ordinary case, in the ordinary course, no, because you will either have a letter of declination if charges aren't brought, or if charges are brought, you will have either a dismissal, conviction, or acquittal. Now, it doesn't perfectly address, every scenario in a way that is crystal clear, but it does provide at least a clear and predictable guidepost, one that is actually workable. The arbitrator's decision in this case, as affirmed by PERB, is simply not workable. Under that scenario, under what PERB has authorized, an arbitrator could pick any date, any deadline for when the tolling provision has begun or ended, which means MPD would not have any way to know in real time when the 90-day clock is running. And that is simply inconsistent with how a statute of limitations does work and is intended to work. And so I think that demonstrates, quite convincingly how this decision by the arbitrator is contrary to law. I would also want to point out why, if I may, there is no additional basis for any deference to the arbitrator's decision. I've explained how contrary to law is a limitation that's imposed by the CBA. The parties cannot bargain for an award that is contrary to law. The FLRA, the Federal Labor Relations Act, is an analogous statute, and so I'd ask the court to look to that. PERB doesn't even address it, ignores it, but it is the analogous statute. It governs federal public employment arbitration, and it authorizes, as I've said, the setting aside of any award that is contrary to any law. And as interpreted, this has meant de novo review of an arbitrator's legal conclusions. And this court, has looked to comparable federal law for guidance before, and this provides strong guidance for here on the proper interpretation of Section 51031. Furthermore, the council did not intend Section 51031 to receive deference. And that is, first of all, well, I would step back and say that is the ultimate test of when deference is accorded. It has to be based on a legislative intent. Here, Section 51031 is not part of the CMPA. It's not something that PERB would administer, so even PERB would not get deference. Again, the council intends through a limitations period to establish clear and predictable guideposts, not something that is subject purely to speculation and guesswork about when the time period is running. And in fact, the council made clear in its legislative history that no one benefits if any part of the rule was confusing. The legislative history makes clear that the council is attempting to make the application of the rule clear in a way that you would not have inconsistent results by arbitrators. There's also the serious public safety consequences that would result from decisions like these, which involve police officer misconduct, potentially egregious misconduct, and the ability of an arbitrator to bar any discipline at all for that misconduct. The serious public safety consequences inherent in that suggest that there is, and the council intended, meaningful review. And deference is also premised on consistency by the agency's decisions. We've pointed to the Glover case and the Turner case, where PERB has taken a very different position than it does here on appeal in terms of when and to what extent it will review a decision on a 90-day rule by an arbitrator, and the type of analysis it does employ, which is consistent with the de novo review we are suggesting here. And even if there was some entitlement to or some requirement that the award be clearly contrary to law or contrary to clearly established law, something that's not in the statute, but even if it were there, we would submit for the same reasons that I've argued in terms of the language, the precedent, the manifest purpose of the tolling provision, and the canon of construction that we've cited, and that this court has recognized most recently in the Miller case, that where a statute of limitations is applied against the government, it must be strictly construed in the government's favor to allow government action when, as here, the government is acting in the public interest. And so applying all those sort of rules of construction, the department submits its interpretation of section 51031 as the correct one. It is clearly the correct one, and therefore the award is contrary to law and must be set aside.
Okay, thank you, Mr. Schifferle. Unless my colleagues have any additional questions for you, we'll give you a few minutes on rebuttal, but we'll hear from PERB now. Mr. Simpson, how will you all divide your time?
I think we will split our time evenly. Thank you.
Okay, and at some point, I'm sure you'll get to this anyway, but when you're opening or soon thereafter, would you address Mr. Schifferle's point that you did not address the FLRA?
Well, thank you. And so I may please the court. I'm Jeffrey Simpson on behalf of the Public Employee Relations Board. So what PERB has done and what PERB has always done is that it has interpreted section 1605.02 as consistent with the NLRA, which provides that is the Federal National Labor Relations Act, that provides for review of arbitration awards in the private sector. And PERB has for decades followed the NLRA in review of arbitration awards. The FLRA has different language, specifically with review of arbitration awards, that calls for de novo review, which is not contained in the CMPA. And that's the reason for the distinction. And there is no reason to look to any cases under the FLRA, even though facially it may seem closer because it is review of public employee arbitration. But in reality, the language of the statutes are significantly different, and that is how PERB has come down on this for decades. So what the court's questions and what is on review here ultimately is a factual determination by the arbitrator about whether or not there was a criminal investigation ongoing after charges were brought.
You insist that it's a factual determination, but there seems to be a legal quality to it. Once we know that a case was pending, what is the legal effect of that?
So the legal effect is that, there may be a case pending, but then there still remains the question of whether there's an investigation. And so the court's observation that in other cases an affidavit was provided demonstrating a continued investigation is a good one. If MPD seeks the benefit of tolling, they have the obligation to show that there was a criminal investigation underway. And so that's all that's required.
Let me get you back to where this started, which is a ruling by an arbitrator named Kaplan, which, and I'll choose my words carefully, is woefully uninformed about criminal investigations. that ruling seems to be taking on a life of its own. And in this case, another arbitrator said, well, I'll go along with that. And then PERB says, well, they haven't shown it's clearly wrong, contrary to law. And then we get an ignorant interpretation of the statute prevailing because of our different standards of review.
So I will say that I don't think that the Kaplan award was not considered controlling. The arbitrator reviewed and looked to it to the extent that it could be persuasive at all, and examined and criticized, if I recall the award correctly. But still came down on the position that there has to be some evidence of an investigation. That's all the arbitrator was looking for. And in fact, at the beginning of his discussion, the arbitrator said, and this is at the joint appendix at page 269, the absence of an arbitration hearing left the arbitrator without the opportunity to seek clarification on such matters as the MPD's investigative practices and procedures. The arbitrator was looking for some concrete evidence of an investigation.
But
And
he was doing that only because arbitrator Kaplan thought that there was a bright line rule that when the arrest occurs, the investigation stops. And that seems to me to be a poor foundation for considering this question.
So I would agree that that is a poor foundation for considering the question, but it is not a legal determination by Kaplan or this arbitrator. What arbitrator Kaplan did and the arbitrator Trosh in this case did to a much lesser extent was to say, making charging a criminal defendant is one marker of when an investigation may end, and beyond that, I need some evidence, any evidence of a continued investigation. So it is still a factual determination, and it's facts based on inferences that may be unwarranted, but it's still at heart a factual determination. And so,
but I mean, it's a factual determination that kind of rests on a presumption, right? When you bring charges, presumably the investigation is over. That is a let's use a kind word, untenable presumption. It seems that 99% of the time, we've only just begun when the charge has been filed. So why would we endorse, even as sort of a rational foundation, that the bringing of charges presumably ends an investigation?
Because the definition of, and so you would, the affirmance of the award and would in no way be an endorsement of that. And in fact, the court is free to criticize and explain why that is wrong, while still determining that as a factual matter, the criminal investigation would require some systematic effort to determine the facts as to the underlying conduct, and whether any such systematic effort was undertaken after the charges were done. And there has to be some record evidence presented to the arbitrator that would support that conclusion for MPD to have the benefit of tolling. So
suppose we view this case and we say PERB thought it had to defer to the arbitrator. PERB says we have to defer to PERB itself. But what we've ended up with is a construction of a statute. When do we get a chance to say what we think the statute means, and to do so in an authoritative way, so that in the future, this is not going to happen again?
So the answer to that is that what PERB's role is interpreting the CMPA as it applies to its review of arbitration awards and what arbitrators do. And so this case wouldn't be a good vehicle for a definitive ruling, but the court can explain its position and provide guidance on these issues moving forward for the OEA, and a review of a decision by the OEA would be a better vehicle for an authoritative statement on the meaning of the section.
So what about PERB? If we lay out a careful exposition of the statute and say, we're convinced this is what it means. The next case comes along and the arbitrator says, I don't care what the Court of Appeals says. I agree with arbitrator Kaplan. And then PERB comes along and says, we got to defer to our arbitrator. That's not a good situation.
No, I don't think that if you set forward the interpretation of this provision, and I don't think, just to back up, I don't think that a determination that there's any particular criminal proceeding, which in all cases would mark the end of a criminal investigation, is one, and I'll set that aside. But if the court were inclined to explain what it means, PERB would follow the court's interpretation of the statute.
And would it require arbitrators to do that?
Yes, because if there's a clear statement on what the statute means and the arbitrator runs counter to the clear statement, then it would be on its face contrary to the law.
So how would you apply that principle to this scenario? In civil cases, it often happens that a Superior Court judge has to interpret a statute. There's no binding precedent out there. The Superior Court judge gives it his or her best shot. It comes up before us. We disagree and say, you got it wrong. We reverse. Could we do something similar here and essentially declare, I'll use put quotation marks around the word retroactively, declare retroactively that the arbitrator's ruling was contrary to law?
I don't believe so, Your Honor. I think that the standard was whether the award was on its face contrary to law and public policy at the time. And I think that underlying this case, that there has been concession that there has been no definition as to when a criminal investigation ends.
So the officer in this case gets a pass, but all future officers are bound by our interpretation of the statute?
That would be correct. And that would be no different than any number of other cases and scenarios where there are changes in law and changes in standards applied. You can see it, I practice in employment law, and there are different approaches taken to summary judgment standards, between judges and over time. And cases that would have been won at a later time, and you kind of look back and you shake your head and wish I had this set of judges in the future. And that's that's the nature of the beast that we're dealing with. So I believe that my time is up, and I don't want to step on Mr. McCartan and what he has. I have other points that I'd be happy to make.
If anyone has questions, certainly happy to extend your time, but otherwise I think I will move on to Mr. McCartan. Is that okay with my colleagues there? Yes. Okay. All right, Mr. McCartan, you're up.
Thank you and good morning. May it please the court, Daniel McCartan here on behalf of the Fraternal Order of Police, Metropolitan Police Department Labor Committee. Largely, I'm in agreement with everything that Mr. Simpson just argued about. This case involved a bargained for arbitration between the Fraternal Order of Police and the Metropolitan Police Department. Pursuant to the collective bargaining agreement that the parties have, Officer Lopez, through the union, presented an appeal of his termination to an arbitrator. One of the issues presented to the arbitrator was whether the case was barred by the 90-day rule. The arbitrator reviewed that issue pursuant to what he was asked to do under the party's CBA. He reviewed it, as Mr. Simpson said, factually, and found that factually there was no evidence presented by the department to indicate that any criminal investigation continued after Officer Lopez was charged with a crime.
Doesn't that factual determination depend on what I'd at least call a quasi-legal ground that pending charges themselves are not evidence of an ongoing criminal investigation? And that was arbitrator Kaplan's reasoning. That was really the arbitrator's reasoning here. Once charges are brought, I think arbitrator Kaplan said it would be irresponsible for a prosecutor to bring charges before the investigation has concluded. So just as a matter of law, when charges are brought, the investigation's done. That's, contrary to all experience with how the criminal justice system works and when investigations begin and end. So I get that you'd want to describe it as a factual finding, but to say it really seems like it's based on faulty reasoning, that charges mark the end of an investigation. It doesn't sound like a factual ruling to me, so why do you think it is?
The arbitrator in this case did not rule that as a matter of law, in all cases, the bringing of charges will mark the conclusion of a criminal investigation. Instead, what he found was that in this case, there was no evidence that any criminal investigation went further. As Your Honor described in the during the argument from Mr. Schifferle, the department has argued different guideposts or different timelines for when a criminal investigation ends. For example, in the Jordan case that they rely heavily upon, in that case, the department's position was that the criminal investigation concluded with arrest. In the Evans case, I'm not familiar with it, but based on Your Honor's description of it, they argued that it doesn't conclude until well after that fact and even after a dismissal of the charges. In this case, they're arguing that it's the dismissal of the charges. But unlike, as Judge Fisher pointed out, unlike in the Merritt case, they presented no evidence. They presented no affidavit to show that a criminal investigation was in fact occurring. Now, they attempted to add evidence to the record in this case in their brief that was not in front of the arbitrator, but even that evidence shows that a criminal investigation was not occurring until the time of dismissal. For example, in April of 2010, there was a hearing in which a plea agreement was entered into, subject to which Officer Lopez admitted criminal responsibility. All that was left for him to do was to complete John's School. That all happened outside of the 90-day rule. So that would still meet time barred. So Officer Lopez, in this case, factually, in April of 2010, admitted criminal liability. It's on Addendum 8 to the department's brief. And so he then went to John's School. That was completed on May 1st, still outside of the 90-day rule. And so the department wants to bring it all the way to the dismissal of charges when there was no criminal investigation going on. Officer Lopez had admitted to guilt. There was nothing to investigate. And most importantly, none of that evidence was presented to the arbitrator. And so this isn't this.
I think the response is, well, we're still investigating whether or not he should be held criminally responsible. And that depends on whether or not he can complete this, what was effectively a probationary term, without committing any other offenses. And the criminal investigation hasn't ended until we've determined that.
Again, that was not presented to the arbitrator. The department is attempting to use a tolling provision to extend out its deadline to bring charges, and at the same time failing to present evidence to support why that deadline should be tolled. And so
what do you think the MPD should be doing? Kind of to the point about whether or not there needs to be a bright line here. Mm-hmm. If the MPD is aware that criminal charges have been brought, do they need to be in constant communication with the prosecuting authority just to see, hey, have you guys done any investigating in the last 90 days? Just want to be sure. Is that how you think it should work?
It depends case by case. They certainly, I can tell you practically speaking, they are in pretty constant communications with the prosecutors to determine what the status of the criminal matter is.
Now, what if the status is, I've got quite a backload here. This is on our list of things to do. We'll probably get to it in about 100 days. And that's really when we're going to kick this investigation into high gear. Until then, it's just going to be on the back burner. Is that an ongoing investigation, or does that answer mean that there's not going to be an investigation for 90 days, so there's not tolling, so the disciplinary action better happen now?
I think the department has two options in that case. They have an option to take that comment as an ongoing investigation, and then at a later time, if they're going to use that to attempt to toll the 90-day rule, present evidence of that when appropriate at a trial board hearing, for example, to prove that it was in fact told and that an investigation was going to be contemplated in the future. Or two, they can decide that that's too ambiguous, it's too risky not to move forward, and move forward with the administrative investigation. Now, what they can do in that situation is one of two things. They can either complete the investigation without interviewing the officer involved. There's no requirement that they interview the officer involved when bringing a criminal notice of when bringing an administrative notice of adverse action. Or two, they can bring him in or her for an interview and issue them garrity. And under garrity, and the department does this, they say, we're requiring you to answer these questions, but we will not use these, then they cannot be used against you in the criminal matter. And so we need you to answer our questions. So they could do that. They could then, and remember, all that this is the deadline, the end point is the bringing of charges. That's done through a notice of proposed adverse action. When the notice of proposed adverse action is served on the member, the 90-day rule ceases to have any relevance. That's the final point. But that's not when an officer is then, for example, testifying in front of a trial board or taking any positions that could harm him in a criminal matter. And so all they have to do is serve him with a notice of proposed adverse action, and that satisfies their requirement under the 90-day rule.
Doesn't it trigger a bunch of other type deadlines though? I don't recall. I mean, it's an interesting point.
There are no other statutory deadlines. There is a CBA deadline, which requires a hearing to happen within 55 days. However, that deadline can be extended. So that deadline can be postponed as long as the parties want until the criminal matter is finished. And so there are no other statutory deadlines that need to be met once the 90-day rule is met. So the department has a way, certainly in the scenario that you gave, and I apologize for the long-winded answer, to comply with the 90-day rule through at least two different avenues.
Let me ask you about the hypothetical about an investigation that has been put on the back burner, but is still contemplated. MPD has brought to our attention a PERB ruling in a case called Glover, and one in Turner. I think in Glover, there had been a lack of email communication for about 30 days. So the arbitrator ruled that the tolling had stopped. And PERB said, no, that's just wrong. You can't subtract periods of silence during an ongoing investigation. And they reversed the arbitrator. Is that ruling from PERB inconsistent with your position?
No, I don't think it is, because in that case, my understanding is factually that officer had not been arrested, had not been charged. Instead, the U.S. attorney was considering whether or not to do those things. And so what was under contemplation was what happens in most cases, not in this case, but in most cases, the department refers a case to the U.S. attorney and says, do you intend to bring charges? And then the U.S. attorney either says yes and then prosecutes or issues a declination letter. In that case, what had happened was the department had sent the matter to the U.S. attorney. No decision, no arrests had been made, no charges had been filed. And the U.S. attorney then got back to them. I don't know how long, but maybe a month or two later, and I believe declined to bring criminal charges. And what the arbitrator said was all that time where you can't say that the U.S. attorney was investigating for every single day are not told. That's consistent with this case, because in this case, the officer was in fact arrested, charged, and arraigned, and that's what stopped the investigation.
So let me give you another chance, because you're going back to the importance of the arrest.
Mhm.
It seems to me what Arbitrator Kaplan said and what you're sponsoring is that when an arrest occurs, then presumptively the investigation has ended, absent proof to the contrary. That presumption sounds to me like a legal concept, not a factual finding. So convince me that it's factual.
Well, I don't think there were any legal presumptions, in my opinion, made by the arbitrator in this case. But he was searching for evidence that an investigation was continuing after an individual was not just arrested, but brought to court, charged, and arraigned.
He was doing that. He was doing that because he was persuaded to follow the path blazed by Arbitrator Kaplan. And it seems to me Kaplan was erecting a legal presumption.
And I don't view it that way. The department, as they've shown, can overcome that, if you even want to call it a legal presumption, by presenting an affidavit like they did in the minor.
So we'll call it a rebuttable presumption, but it's still a legal concept.
I think it's a factual analysis of when those two arbitrators believed a criminal investigation was taking place. I think more often than not, in these cases, it's the situation that I was just describing earlier, in which a case is sent to the U.S. attorney to actually investigate the matter and determine if they want to bring criminal charges, as opposed to where someone has actually been arrested, charged, and arraigned, and there really isn't much investigation left to do because they have been arrested and charged with the crime already.
But you keep using those terms in describing basically a legal line.
Pardon me?
You keep using those terms in a way that seems to basically describe a legal line. You are describing this as all factual, but when you are distinguishing other cases, you always come back to that.
Well, and I believe in this case that it is accurate that it's factual, because even factually in this case, there's no evidence that, even with the evidence presented by Mr. Schifferle in his brief, that any criminal investigation occurred after the arrest. There was a plea agreement entered into. There's no allegation that the police continued to investigate, that the prosecutor continued to investigate. Instead, Officer Lopez entered into a plea deal and went to John School, and that was the end of it. So factually, the arrest in this case is a demarcation line, because there is no evidence, even after the fact, even the evidence not presented to the arbitrator, to point to say, well, actually, we did still conduct an investigation. We thought about bringing other charges, anything like that. It just didn't happen.
I'm still having trouble with your premise. It seems to me that anybody who has prosecuted a criminal case or defended one would laugh at the proposition that investigation stops when the arrest occurs. even though there's a case pending in court. Why should we give some sort of deference to that sort of concept?
Well, I think that goes back to the standard of review in these cases. Again, it was a bargain for arbitration. The arbitrator made findings. PERB then did not itself interpret the 90-day rule, but simply ruled based on its narrow standard of review that what the arbitrator did was not contrary to law on its face. The court then reviews PERB's review to determine if PERB had, if its finding was erroneous, which it was not. At kind of going back to the beginning of this argument, the court has reviewed this 90-day rule a few times. In the Jordan case, the court found that in some instances, an arrest will mark the end of a criminal investigation. In the Butler case, the court found that it is a highly factual analysis. And so it doesn't, the parties agreed to have that analysis, that factual analysis, performed by an arbitrator. And they bargained for that arbitrator's analysis of this, of the facts and of the 90-day rule.
Okay. Mr. Parton, thank you for your argument, and we will give Mr. Schifferle 3 or 4 minutes.
Thank you, Your Honor. I think as the preceding argument shows, this all ultimately comes back, the arguments on the other side ultimately all come back to this legal presumption that a criminal investigation concludes as soon as criminal charges are brought. And that simply is not so and is contrary to law. In addition, the arbitrator's decision simply ignores the undisputed facts. Part of the facts in the arbitrator's decision is that there was this agreement for completion of John School, but then the defendant came back at that hearing on May 19th with proof of completion of that diversion program. The prosecutor necessarily reviews that new information, that new evidence, and necessarily makes the decision that continued pursuit of criminal charges are unwarranted. So the undisputed facts also show the existence of a criminal investigation. I think it's noteworthy that, as Mr. Simpson noted, that PERB doesn't even consider the Federal Labor Relations Act, which is the analogous federal statute, the federal counterpart. He says that PERB relies on the NLRA. The NLRA doesn't even apply to government employees. There's no suggestion that has any comparable provision like the CMPA does for review of arbitration awards for awards being contrary to law.
Does it matter if PERB, according to Mr. Simpson, has been relying on the NLRA for decades?
No, because it's still erroneous, not, to rely on a different statute rather than the comparable statute, the statute that does have a comparable provision that these awards are reviewed for being contrary to law. And as that has been interpreted under the federal statute, that includes de novo review. There's no justification for simply ignoring the relevant federal counterpart. With respect to the point that Mr. McCartan made, that, well, the department can always just move forward with the investigation, the disciplinary investigation, even if there's a criminal case out there. I think he understates the harm to officers and employees in that circumstance, because it does mean that the department, as is its right and would be proper in any investigation, to interview the employee. And that creates precisely the Fifth Amendment concerns that I've articulated. The fact that the department could offer a grant of immunity, the department's not required to, and that would be ultimately up to the prosecutor, who's not required to. And there's all sorts of disadvantages with that, because then it taints the criminal case by making it difficult to determine what evidence has been acquired that is independent of anything that the officer may have said. But also, too, there's the prejudice to the government from parallel criminal and disciplinary proceedings. The prosecutor may not want, and rightfully so, may not want to disclose evidence to be used in the disciplinary proceeding, because that would broaden the rights of the defendants to discovery under the rules of criminal procedure. And the fact that the disciplinary proceeding would churn over the same evidence as would be later introduced in the criminal case creates all sort of problems for the prosecutor. So there's the prejudice to the governments as well. That is not negated by what Mr. McCartan has suggested here. Moreover, the department is entitled to conduct a full and appropriate investigation. So that involves reviewing all the evidence in the case, interviewing the officer, and then making a determination of what charges are appropriate and what the basis for those charges are. And so simply to say the department could file a notice of disciplinary action does not address the underlying problem of that there has to be an investigation first before the department can meaningfully proffer disciplinary charges. And once those disciplinary charges are filed, there are automatic sort of timelines that are invoked. The officer has only 21 days to file a response. If the officer requests a hearing as part of that response, only 55 days then for the department to issue a decision. There's no provision for an automatic stay. I mean, maybe the parties could agree, but there's all sorts of complications that would be entailed in reaching agreements on that. That's why there is a tolling provision in the first place. We don't need to resort to this extra procedural method when Section 51031 takes care of it through its tolling provision. So it simply does not make sense to invoke that. And as I said, in light of the purpose of the tolling provision, it would make no sense, as Mr. McCartan suggests, that the department should simply proceed with the disciplinary investigation when there is a criminal case ongoing. So I would just state that, in conclusion, the arbitrator's decision is it defeats the very purpose of the tolling provision. It renders the statute entirely unworkable in practice. It rests on an indefensible legal presumption, and it simply ignores the undisputed facts and conclusion that there is a criminal investigation. There was a criminal investigation until the dismissal of the criminal charges. If there's nothing further, we would ask this court to reverse.
Thank you, Mr. Schifferle. Thank you also, Mr. Simpson and Mr. McCartan. We will take this case under advisement, and you are free to log off now.
Thank you, Your Honor.
This court will take a short recess to prepare for the next argument.
Hello, everybody, and welcome to the newcomers to the DC Court of Appeals in this virtual session. I will call the case. It is number 19 CF 481, TERELL Kelly versus United States. Ms. Daniels, could you let us know how you are planning to divide your time?
Yes, I'm going to divide my time with amicus, Mr. Collins, equally.
Great, thank you.
And how much time do we have? We weren't sure.
Good question. I think you have 15 minutes per side, but you are often generous with that in a case like this.
Well, I'll still divide my time equally.
Ms. Ament, are you here? And you are muted if you are. Just want to make sure.
Can you hear me now, Your Honor?
Yes, we can. Thank you. Just wanted to make sure you were here before we got started. Ms. Daniels, whenever you're ready. Assuming you wanted to go first, I'm sorry.
I was going to let Mr. Collins go first.
There you go, Mr. Collins.
Good morning, Your Honors, and may it please the court. William Collins on behalf of the Public Defender Service as amicus curiae. I would like to reserve a minute of my time for rebuttal, and I will be addressing the first issue on which this court ordered supplemental briefing, whether the Constitution requires a jury determination as to matters of territorial jurisdiction in the District of Columbia. Under some recent Supreme Court case law, a jury determination as to territorial jurisdiction in Superior Court prosecutions is required for two reasons. First, because the law makes jurisdiction essential to punishment. Second, because jurisdiction was submitted to juries at common law when the Constitution was written. For these reasons, this court should rule that the panel opinion in Adair versus United States has been substantially undermined. I'd like to start by addressing why territorial jurisdiction is legally essential to punishment, focusing first on the argument that we've raised with respect to Article 1, Section 8, Clause 17 of the Constitution, the federal enclave clause that authorizes the Congress to control the district. So the Supreme Court has emphasized that whether a finding is legally essential to punishment is not one of form, the inquiry is not one of form, but of effect. Territorial jurisdiction has to be legally essential to punishment within the meaning of these cases because it is a requirement for criminal code offenses to be valid under Article 1, Section 8, Clause 17. Code offenses have to be read this way because Congress can't punish felonies generally and may enact only those criminal laws that are connected to its constitutionally enumerated powers. The enumerated power under Article 1, Section 8, Clause 17 is geographically restricted to the districts and other territories acquired from states for specific purposes. Therefore, the code must be read to require some finding that the offense occurred, at least in part, in the district to preserve the appropriate balance of police power between federal government and the district's neighboring states.
Counsel, can I? Go ahead, Judge Fisher.
No, I was wrapping up. Please, Judge McLeese.
Go ahead, Judge McLeese.
Sure. Thank you. As an overarching, you said there are two reasons why you think a jury determination as to geographical jurisdiction is required here. I just want to make sure I understand. Are those two independent reasons, or are those two reasons that need both to be present in order for the requirement that you are asserting to arise?
I think after the Supreme Court's decision in Oregon versus ICE, both determinations have to be present. It has to be both, I should say, under the Apprendi line, it has to be both a finding that is legally essential to punishment and also one that the jury made at common law. If you have one, and not to get too complicated, if you have a finding that the jury made that is that the jury made at common law, I think there is a very strong argument to be made but you know, apologies, that the jury made at common law, but that is not legally essential to punishment as the Apprendi line of cases deals with. I think there's a very strong argument to be made that this would also qualify for Sixth Amendment protection, but it's a little different and it's sort of not the argument we're making here. And I'm happy to talk more about that because I think it's.
That relates to, I guess, a further question I had. To the extent your argument here rests essentially on the idea that the Apprendi line of cases applies, which is sort of what I take your answer right now to suggest. I want to make sure I understand how you think it applies. The way you've worded things is you think a jury determination is required. Do you mean in the sense of, like any other element, therefore it needs to be alleged in the indictment? In an indictment case, it needs to be found by the jury in every case without regard to whether there's any particular evidentiary, anybody's disputing it or there would be any reasonable basis for disputing it? Or do you think it operates somehow differently from the kinds of elements that Apprendi addressed, or things that were essentially treated as equivalent to elements that Apprendi addressed?
So as to, it has to be alleged in the indictment, most certainly. It has to be proven beyond a reasonable doubt, also most certainly. The position we took in the briefing, or our understanding is that there are many jurisdictions that treat jurisdiction somewhat differently than other elements, in that it need not be proven in every case, only in those cases where there's some dispute of fact arising, or some evidence, however slight, to use the district's parlance, and as far as that is concerned, We think that's still consistent with a categorization, an elemental categorization for the reasons we cite in the reply brief. Under Comer, there are certain elements or aspects of elements which the government need not prove unless some dispute of fact arises in the record. With that said,
okay, can you say how do you think Comer supports that? Because I mean, ordinarily, I would have thought that something that is an element in the full-blown sense of it is something that needs to be proved in every case, without regard to who's contesting what and without regard to what might be factually reasonably disputable. But you're saying you think there are, you would agree that's true of most elements. Those things are true of most elements?
I agree that's true of most elements, and I would further agree that's true of the jurisdictional elements that we cite, the federal jurisdictional elements that we cite. But sorry, you were saying, Judge McLean.
Well, no, but you think that the decision in Comer identifies something that you at one point said an element, and then you said an aspect of an element, so I'm not quite sure which, that actually doesn't need to be proved up to the jury in every case. It only needs to be if there's a dispute of some kind. What is the element that you think in Comer was needed to be proved only if there was a reasonable dispute about it?
It's the absence of justification or excuse that is relevant to the determination of whether the government has proven malice. That's the language in Comer I was referring to. So malice is always an element of second-degree murder and manslaughter, but the government need not introduce, or sorry, the jury need not be instructed on that issue, on the issue of excuse or justification, unless it's an issue raised by the record. But getting back to,
I guess I had understood that as essentially meaning that the absence of justification or excuse was an affirmative defense rather than an essential component of the element of malice. But you think that, I mean, is there any other example besides the Comer example of something that is constitutionally an element, but that need not be proven to the jury in every case?
None I can think of, Your Honor, and I do not dispute your analysis of Comer. And to be clear, if our analysis with respect to this issue of whether it must be proven in every case or only in certain cases is infirm in your estimation, our position is that it is an element and it has to be proven in every case.
Does that mean that you think a defendant need not raise the question of territorial jurisdiction in order for the judge to be obliged to instruct it to the jury?
Yes, along the lines of what I just said to Judge McLeese, I would concede that.
So everybody agrees that this crime took place in front of the Moultrie Courthouse. It's still an element of the offense that the jury has to determine?
Yes, I mean, yes, it would be, that is how elements are treated. Now, I would think it's no issue for an instruction to be given that says you must find that one element of this offense occurred within the District of Columbia in order to return a verdict of guilty on this charge. That is a very simple thing. But
can I ask you, is the logic of your argument that self-defense needs to be instructed to the jury in every case of like assaultive crimes without regard to whether there's evidence? Because I mean, the absence of an affirmative defense is essential to punishment, or maybe it's only essential to punishment if raised. And I think it probably is true, though I haven't independently looked into this. My recollection is that it's true that there's a long common law tradition of juries making determinations about self-defense. So is that where this tends to head?
Well, no, Your Honor, but I may have to go back to the language of Comer, because I'm pretty sure it says that the absence of justification, I mean, I'm not sure that those things are affirmative defenses, and the government's burden to prove them when the evidence raises those questions, only when the evidence raises those questions. I don't think it undermines the sort of categorization we've set up as far as territorial jurisdiction is concerned. But I think getting back to our issue, it's a necessary component of the statute that these offenses happen within the District of Columbia, and it's a necessary component of congressional lawmaking authority that these components happen in the District of Columbia. And under those circumstances, I think the case law is pretty clear. These findings need to be made by juries.
Well, again, the way you're saying that now, you're suggesting that if it's necessary to punishment, then the jury has to make the finding constitutionally. And I thought your argument is more complicated than that. It is, if that's true, and also there's a tradition in common law of the jury is making the relevant determination, because there are lots of other things that may be essential to punishment. I mean, it may be that the trial judge's status as a judge is essential to the trial judge's ability to lawfully impose punishment. It may be that, whether a statute, like a federal statute, is consistent with the Commerce Clause, if it doesn't have an express element like that, that might be essential to the lawful imposition of punishment. But I took your reply brief, at least, to suggest that you're not arguing that the jury has to make every finding that is legally a legal prerequisite to punishment, lawful punishment, only those where there's a common law tradition of jury involvement in the decision of the issue.
That you've read our reply brief correctly, and I'm sorry for omitting that aspect in my answer just now. The common law portion of it is a necessary condition.
And does it matter to the common law point you make if the role of the jury in deciding the issue is not really the role of a jury typically with elements in the standard element, where I think you agree that things that were treated as essential to punishment in that sense, the jury was required to make a finding on them in every case without regard to who was contesting what. And if the role of the jury in
common law in deciding geographical jurisdiction was more limited and was instead more like it was treated as something like an affirmative defense, where it would get teed up if raised, it would be teed up. If it was, I guess, both A, raised, and B, maybe there was some factual basis for the invocation of the concern. How does that affect your chain of reasoning, which is, jury involvement in common law plus legal necessity to punishment means full-blown element?
Well, I think the Apprendi line of cases applies both to elements and those things which are their functional equivalent. I don't think the common law, I don't believe that would undermine our position necessarily. The test that's been articulated in terms of the common law inquiry, I don't think it's whether the crime was hard and fast understood to be an element. I think the issue is whether the jury was in charge of finding that fact whenever and however it came about. I also think, for one thing, the government hasn't argued that this particular distinction that you're raising, but and I'm not aware of any authority to support that. But yes, I think the sort of uninterrupted history of jury consideration of these issues supports us. And I would say I would take it a step further, Your Honor. The cases that we've cited, these cases that deal with special verdicts and whether they include a jury finding as to territorial jurisdiction, they don't question at all whether the issue was raised by the defense or whether the issue, is implicated, whether the evidence implicates it in a certain way where you can say it's truly in contest. The issue, it's just an appellate court saying the jury did not find that this offense occurred within the lower court's jurisdiction, this special verdict is no verdict at all. It can't be the basis for punishment. So I think that very strongly supports that this is in fact elemental in the traditional sense.
And can you, I think you said something about this, but I'm not sure it fully sunk in. So can you explain why, on the logic of your argument, self-defense isn't required to be treated as a full-blown element that would be instructed to the jury in every case as to offenses where it would operate as a legal defense, without regard to whether anybody's invoking it and without regard to whether the evidence reasonably suggests it? I mean, it's legally necessary to punishment, at least, again, maybe if raised, but certainly if raised, it's legally necessary to punishment in a case where, with respect to an offense where it operates as a defense. And there is, I believe, a long tradition of juries being involved in making that determination.
I think it seems to me that it's a fact proven in every case by the absence of justification or self-defense. The absence of self-defense is necessarily proven by the evidence that the government puts on of the way that the crime occurred, the malice, the mens rea, I would think. And then so I don't know that I just don't, I think it is an element. It's in there with the malice finding. The jury is being charged with finding that. They just don't get an instruction on it every single time. I would think they're finding that malice occurred in any given case is effectively a finding that there was no self-defense.
Well, a lot of assaultive offenses don't require that's the mens rea. And so I'm not, even if that were true as to offenses that required malice, I'm less sure it would be true. I mean, again, if I was charged with assaulting you and the government's evidence was I punched you, I mean, that would meet the elements of assault. And if you said, and if I said, no, I did it in self-defense, that would be separate from what the jury would have to find in order to find the elements of simple assault as I would understand them. So I'm not sure that would work I'm not sure it works as to malice, but it seems like it's less likely to work as to other assaultive offenses that don't require malice.
Mr. Collins, what do you think a proper jury instruction would look like in some instances? For instance, does the court have a role in instructing the jury as a matter of law that a particular location is within the District of Columbia? So then it would be the jury's job to determine as a matter of fact where the crime occurred, if there was one, but they wouldn't have to figure out in each and every case whether that location was within the District of Columbia.
Yes, Your Honor, I think that is correct. That's consistent with federal practice currently with these prosecutions that arise under federal enclave laws and the federal enclave clause, which we've cited. And it's also consistent with a bunch of the older cases that we also cite in our brief. The jury determines the locus of the offense, the site where it in fact occurred. That's the matter of fact. And then judges may determine the boundaries of the relevant territory. And they can do so through judicial notice and the various means that judges have to decide those questions.
What do you mean by territorial jurisdiction? I'll give you an example. I can't remember the name of the case, but everybody agreed that the threats to the witness took place in Maryland, but the witness was going to be a witness in a Superior Court case. Is that territorial jurisdiction?
I think so, because I'm not sure if the prosecution was for witness tampering or for obstruction, but the official proceeding element of it is in the district. And if one element of the offense happens in the district, that's territorial jurisdiction.
So the territorial jurisdiction encompasses not only location of the parties, but also in some cases, the impact of their actions?
That's exactly right. And we don't, it's an offense by, or a crime by crime analysis. And, I believe there's a case where the threat was received in the district. That result element then is, satisfies the jurisdictional analysis. We're not attempting to suggest that anything about that is wrong. We think it's perfectly accurate.
In our cases, there's a presumption which says it is presumed that a court has jurisdiction over a case that is pending in it. Under your argument, does that presumption fall?
Yes. And what I'll say is, I think where the government goes to trial and rests on nothing but a presumption, that should, as a matter of law, be insufficient evidence, and a motion for judgment of acquittal should be granted, or in the judge's discretion, the case could be reopened. But it's not, I think it's part and parcel of it being jurisdiction being an element.
Can I ask you about, it's a component of your argument you haven't touched, I think, directly on today, but I believe it's a component of your argument. The territorial or geographical jurisdiction in this sense goes to the court's subject matter jurisdiction and therefore can never be waived. Am I right that that's an aspect of your position?
That's an aspect of our position, yes.
Does that mean logically that if the court in this case were to rule that territorial jurisdiction is an element, that everybody who has been previously convicted under a different understanding, many thousands of cases where there wasn't any jury determination of element, all those claims could be raised without any, on collateral review, without any sense of any kind of procedural default. And the sole issue, I guess, would be whether the prosecution could show beyond a reasonable doubt that the failure to have treated it like an element didn't affect the outcome of the proceeding in a required sense. Is that correct? Am I correct that that's the consequence of the position you're taking, or is that not right?
That doesn't follow from our position, Your Honor. And the Sixth Amendment right that's, we're asserting here that's at issue is waivable as far as I understand, and subject to procedural default and plain error review and everything else that preserves the finality of convictions. So I don't think.
So the idea would be I'm just not quite sure. If the Constitution requires that subject matter jurisdiction be determined in a particular way, you're saying that if you don't invoke that right, your right, although the need to have a determination of subject matter jurisdiction remains unwaivable, is your point that the claim that the Sixth Amendment entitles you to have a jury decided in every case is a defaulted claim, and that therefore what defendants on collateral review would have a right to would be to a decision that in fact there is geographical jurisdiction, because no one may have made that determination yet, and that's unwaivable, that there must be geographical jurisdiction, but that the claim of an entitlement to have it treated as an element and have the jury find it is waivable. That's not an unreasonable view. I just want to make sure that is that the logic of what you're saying?
That's the logic of what we're saying. And I would say, geographic jurisdiction is already subject to proof beyond a reasonable doubt under this court's case law. That's Mitchell. There are, Apprendi claims and Booker claims and the like have been subject to, those are waivable. That is according to Supreme Court case law. So I don't see a flood of applications for review based on a decision recognizing that there's a right to trial by jury that attaches to this issue.
Let me press you on that a little bit. Roughly speaking, the right to trial by jury depends on the level of punishment. And so are you saying that a defendant going to trial for murder would have to demand a jury trial on the question of territorial jurisdiction?
If Your Honor is asking, should they, if they were demand, or if they have to demand a separate jury trial on the question of territorial jurisdiction?
No, I thought you and Judge McLeese were saying that the right to have a jury determine territorial jurisdiction could be waived.
That's correct.
I thought you told me earlier on that a defendant need not contest jurisdiction in order for there to be a requirement that the jury decide the question. So I'm not sure what a defendant has to do to preserve the issue.
Thinking about the question in that particular way, Your Honor, I do think there is potentially some plain error analysis that could be implicated if there is a failure to request an instruction, because I think it's you invoke your right to trial by jury in a certain way below, and then you request jury instructions in a certain different way below. And our position is the jury instruction on territorial jurisdiction should be given. If it weren't given and the defense didn't ask for it,
I think you'd come in arguing structural error, wouldn't you?
We'd come in arguing structural error. I think that's right. Apologies. These are very good questions.
That leaves me confused about whether a defendant has to contest territorial jurisdiction in order to get a jury decision on the question.
The answer that is consistent with the federal case law would be no. It's a structural error to fail to give the instruction, and it need not be requested specifically.
Thank you.
If you're wrapped up, Mr. Collins, we will hear from Ms. Daniels next. Thank you.
Yes, thank you. I'll reserve a minute for rebuttal as well. Well, we know in this case that it was contested and it was preserved. I'm going to address the other issue that the court asked the parties to address, which was Morales. And in this case, the government did not argue that it was harmless beyond a reasonable doubt. And Morales says any discretionary authority to sua sponte address it must be exercised with restraint and only when harmlessness is obvious. And that breaks down to whether or not the issue was debatable. And in this case, the defense did feel that the issue was debatable based upon certain things that the complainant said about when things occurred, as well as a supplemental police report that changed a report that said everything happened in the district to everything happened in Prince George's County, Maryland, as well as a be on the lookout that was issued that said the crime occurred while en route to DC.
Ms. Daniels, what do you do about the fact that the video evidence that is clearly in the district showing your client walking off the train with the bag? Doesn't that definitively show that part of the crime happened in the district?
Necessarily. What the defense argued in the trial court was, I want to be able to argue to the jury that aspiration, that given the jury instruction on asportation is the least removal is enough to show a carrying away. And what the defense wanted to argue was that whatever occurred before he actually got off in the district, and I don't dispute that he got off the train in the district, but what the defense wanted to argue at trial was that asportation, that even the asportation element of it, at least in terms of the instruction of even the least removal, is enough to show a carrying away.
Your answer seems to assume that if there is enough asportation for the crime of robbery to have been committed, that the asportation, as soon as there's enough to constitute robbery, the asportation is over and the robbery is no longer continuing. Do you think that's right, or do you agree that there can be enough asportation to have given rise to a robbery? There's now a robbery that's been committed, but then there's more asportation and the robbery is continuing? Or do you think really it's just like there's always a moment where the robbery hadn't been committed because there wasn't enough aspiration, and then boom, there's enough aspiration, and now the robbery is continuing, it's over? Which do you think it is?
Well, I think it's the first. I think that it's arguable.
I mean, that's really a legal question, though, about whether a robbery is, I mean, the word completed is very confusing in discussing this topic, but it's a legal question whether the way there's enough asportation for the defendant to be guilty of robbery, then as soon as there is enough, the robbery is over and it's not continuing. That's a legal question. Is that how you think robbery works? Or do you think instead it works differently, where there can be enough asportation that the defendant is now guilty of robbery, but there's still more asportation going on, and during the period until asportation ends, the robbery is ongoing? That's a legal question, which way robbery works. Do you have an answer to that legal question about whether, which of those two ways of looking at robbery is correct?
I don't think that, well, again, I'm going to say the first scenario where there is a point where asportation can end. And in fact, the case law says,
I mean, both of those,
well,
both of those scenarios contemplate the idea that asportation eventually ends. The issue is asportation over as soon as there's enough of it for the defendant to be guilty of robbery, to have committed a robbery, or does asportation kind of last for a while, where there's enough of it now that the defendant has committed a robbery, but it's still ongoing. And in both of those scenarios, robbery, the asportation eventually ends. That's certainly true.
Well, the case law says that asportation element of robbery only continues so long as the robber indicates by his actions that he's dissatisfied with the location of the goods, hasn't felt he's reached a place of safety, or continues in a robbery context, continues to be retained through a threat of force. And so we would say that in this case that there was none of that, and that the defense could have argued that to the jury that Kelly wasn't dissatisfied, there was no pursuit, it wasn't really a safety issue, and so it did end, and it wasn't a continuing thing. And I would point out that, as we do in our pleadings, that when robbery is part of felony murder, that it's left up to the jury to determine when asportation ended and whether or not what occurred was actually a felony murder or a fresh crime. So in Carter and Castillo Campos, the case that the government cites, it was still left up to the jury to factually determine when asportation ended or when it was still in progress.
What do you make of your opponent's the statute, the other statute your opponent cites, DC Code 22-1808, which seems to be independent of asportation? It would be a ground for jurisdiction in the District of Columbia, a sufficient nexus for prosecution in the District of Columbia that's independent of asportation. So what's your response to your opponent's reliance on that provision?
Well, you know, I still think that even though they rely on that, and that does presume something, it's still a factual matter for the jury to determine when things occurred.
Well, I don't think that presumes anything. It just says that if you commit an offense outside the district of an act that would be a crime inside the district, and you thereby get property and are found with that property in DC, you're treated as though you committed the entirety of the offense. The offense that wasn't committed in the DC, you're treated as though it was. And so if imagine this were an element and imagine the jury had to be instructed on it. Do you agree that a part of that instruction would have been to tell the jury about this provision?
Well, I don't know. I mean, we don't know how things would have landed in the trial court because there was never a debate about jury instructions and how they would all intertwine. I mean, we still have the instruction that, you know, the least removal enough is to show a carrying away. And so, you know, there seems to be conflict there between.
I would have thought those might be two different alternative ways in which one could show or try to show a sufficient territorial nexus to the district. One would be the robbery was still being committed in the district because asportation was on. There would have been something for the jury to decide about whether the asportation, not only had there been enough of it, the defendant was guilty, but maybe asportation was all the way over before anybody got out of the district. So I get that, but that's just one of, you know, I think your opponent's argument is basically, well, the jury also would have been told in the world in which this is treated as an element, oh, by the way, here's theory number 2 about geographical jurisdiction. In the alternative, you can find geographical jurisdiction if the requirements of 22-1808 are met. And I'm just interested in whether you have a concrete argument about how there could be a reasonable dispute about whether the requirements on the record as it was here, about whether the requirements of 22-1808 were met.
Well, you know, obviously the government would have argued that the requirements were met, and the defense would have argued that the jury could still find that it ended on the defense theory of the case. So the government would have their theory of the case, and they would argue that statute, and the defense would have their theory of the case. But it would ultimately be up to the jury to make the determination of what facts there were. They still have to determine factually where things occurred.
But there was no dispute, as a matter of fact, that Mr. Kelly had the property after entering the District of Columbia.
He had it with him when he left the train in the District of Columbia. When they actually found part of the property, the shoes, that was, he wasn't actually in possession of it. It was his girlfriend.
I understand, but if he had it in the District of Columbia when he left the train, then I don't see how there is a factual dispute about the application of 22-1808.
Well, the point is, though, is that, you know, that's sort of like rendering a directed verdict in a way for the government. And if the defense wished to dispute that, I mean, I don't know exactly. Obviously, trial counsel had something in mind, the way they wanted to dispute it. But to convince the jury that it actually ended before that particular thing happened, or the jury could have just felt that so much of it occurred in Maryland, and decided to just decide that they were going to go with the aspiratation instruction as they're instructed on aspiratation as it is, because otherwise you're really saying that there's it sort of renders a directed verdict when the defense is arguing a factual dispute.
Well, no, I think the idea would be if, contrary to the trial court's view, the question of geographical jurisdiction had to be instructed to the jury, and that was a mistake. Then the question is whether that mistake might have been harmless. And given the United States' failure to initially brief harmless error, whether it is clearly harmless. For sure, if it should have been instructed to the jury as an element, then there was error. And figuring it out now, a harmless error determination now doesn't make the defendant whole in the sense that the jury will not have made the finding that the jury ought to have made. I get that. That's always true in these harmless error or failure to instruct on cases. But the question we're grappling with is if, given the jury's determination that your client committed robbery, and given what seems like the undisputed evidence that if that's true, then the jury found that either in the district or outside the district, your client committed robbery. And if it's otherwise undisputed that your client was then in the district with property from what the jury found was a robbery, then it's a little hard to see how a properly instructed jury could have found no geographic jurisdiction if it found robbery, given what seemed like the other undisputed facts in the case. That's the issue. It's not really directing a verdict. It's a harmless error inquiry if we assume that it was incorrect not to have had the jury decide this in the first instance.
Well, we don't really know what the jury would have decided. I mean, in this case, the complainant said that, he believed he saw a gun, and yet the jury, did not find evidence of a gun. So I think, in any event, not you, but, it would be a presupposing of how the jury would view the instructions and the ultimate result that they would reach, even given, defense counsel's arguments, that, the jury still found that it was over, and, that it wasn't necessarily ongoing, even despite the statute. And I also want to say, I know that the court has been focused on other issues. I just segue here. I just want to say that I'd like to have a few minutes of time before the argument is over to address the sufficiency of evidence issue. And I was asked to address another issue as well as to the Metro card. But to answer the court's question, I mean, a jury properly instructed still could have found that, in line with the defense, that, it was over. Then you have the police report, and, the Detective McCarthy could have been asked, well, why did you believe that all events occurred in Maryland? And so I just don't think it's a given in this particular case and under these facts. And if the defense was able to raise jurisdiction, which it wasn't, to be able to get in the detective's testimony, the detective's report, and why the detective believed that all events occurred in Prince George's County.
I'm not sure I understood one thing you just said. I thought you said just now that the defendant wasn't allowed to get into jurisdiction. That seems to me, the defendant wasn't allowed to get into jurisdiction in front of the jury. That's true. But I thought the trial court did make a determination about jurisdiction, and that matter was, contested and decided by the trial court. And so the defense had a full opportunity, though not from the jury,
but had a full opportunity to get into the question of territorial jurisdiction. Or am I missing something?
No, I'm just saying that because jurisdiction didn't become an issue, that Detective McCarthy was never questioned about.
Well, that's where I'm losing you. If the judge was going to decide territorial jurisdiction, if you thought his testimony was important to trying to persuade the judge to rule your way on that topic, it was entirely free. I don't mean you personally, but it was entirely free to the defense to present that information to the trial court in whatever way was right.
Yes, but with respect to the statute, I think that goes to the as Gayhart analyzed this, that would go to the gatekeeping function of the court, and perhaps so then maybe it would pass that gatekeeping function to point to that statute, but but it would still be a factual matter for the jury to decide. So I would say that the statute more goes to the gatekeeping function than then it's just a slam dunk for the government as a factual matter.
Ms. Daniels, as your time is out, and I know you want to address your other arguments, I would encourage you to focus on the Fourth Amendment issue involving the MetroCard. It's your argument, of course, but I think that's what we'd be most interested in hearing.
Okay, so the court asked the parties to address Commonwealth versus Henley. And I want to distinguish Henley from this case, which is in Henley, police took the MetroCard upon the defendant's arrest and then without a warrant searched it and tracked where he had been. Whereas in this case, they tracked his card to actively track his future movement. So it was more of a real-time tracking as opposed to in Henley, which looked back, and real-time tracking, it would be more akin to, putting some kind of tracker on someone's car or something.
Let me ask you this. Let me ask you this, pause there, if you will. They didn't track him using the MetroCard. At various points, the card let them know where he was at that moment. But a lot of the tracking was done through video surveillance. Are you attacking the legality of the video surveillance?
No, I mean, Metro has video surveillance. But what occurred in this case was they used the video surveillance initially to see when he entered the station. And as a result of that, they were able to find out what card he used. And then
but it's not the same as putting a GPS device on an automobile and tracking the automobile everywhere it goes.
Well, I do think that it is more akin because they latched onto his card and used his card to be able to track him. So it is similar, I think, or at least arguably, to actually, attaching onto a car and watching where it goes. I mean, they latched onto the card itself. It wasn't just taking the card and then seeing where someone had been. And in fact, the next time he used that card, they somehow, I guess, have a system where they got a notice and they got there fast enough and they saw him and Miss Salahudin with the shoes. And they took the shoes and they took some other things, but they didn't arrest him at that time. Then later, and who knows how many other times he used the card, but at some point, a couple of days later, when he used the card again, that's when they decided to go there and arrest him. So, without latching onto that card and without actually tracking his real-time movement, that was the only way that they were able to get the evidence and that they were able to actually find him and arrest him. So I do think it's more akin to, they were tracking the card itself.
Your opponent relies on a Supreme Court case called Knotts that also involved attaching an object to a car and to something, to an item, I think, that was then in a car, and argues that this case is very comparable to Knotts in that it was relatively short information, relatively discrete information, and not like the long-term, highly intrusive, mosaic creating kinds of surveillance that were at issue in cases like Carpenter and Jones. What's your response to your opponent's reliance on the Supreme Court's decision in Knotts?
Well, the mosaic theory is that you take the Fourth Amendment search doctrine to government conduct as a collective rather than in isolated steps. And I don't think that, this court has really looked at the Fourth Amendment in that way. In this particular case, as events occurred, wound up being a short period of time because the card was used again. But in theory, it could have been endless. I mean, they could have endlessly have tracked this, but I can't dispute that, the first time was the next day and the second time actually occurred a few days later. But nevertheless,
there's a difference here too, maybe, in that it's not quite consent, but it's not like a GPS device that is on your bumper and you don't know about it. Mr. Kelly swiped his card or placed it on the reader each time he went into the metro system and came back out. And so it's sporadic, and it's he knows that he's leaving a record.
Well, actually, in Commonwealth versus Henley, the court said that, there wasn't, that use of a Metro card does not mean that the use of the card would give access to whereabouts or consent to police conducting a search or latching onto that card. So I don't think that what Your Honor just said is a given, or that people know that the use of there's no evidence that he knew that the use of the card give access to his whereabouts or his consent. I mean, I don't necessarily assume that when I've used my Metro card that gives Metro access to my whereabouts. It just gets me in the station.
You can't seriously mean that. You might mean you don't understand that MPD would have access to that. But why else would Metro make you swipe your card? They want to know where you started and where you got off so they know how much to charge you.
For that purpose, yes, for that purpose, but not to access to whereabouts, for any police purpose. If I may, can I use just 2 minutes to point out certain things in the sufficiency of evidence argument?
Sure.
Okay, so what we're challenging is the use of force by violence, putting in fear. And, we've briefed the matter. The court knows that the test is, the conduct of the accused and not necessarily the subjective perception of fear. And so I just want to briefly go to the conduct and point out that the complainant, when he was describing what happened, kept saying that Kelly asked him for things. He didn't use the word demanded. He asked. That's page 266 of the testimony. And and goes on from there. But every single time it was an ask. Also, he said, he didn't say he saw a gun. He said he thought that he saw the barrel of a gun. We know the jury, and I'm going to disagree with the government that this was not an inconsistent verdict case, because the jury also found not guilty on quid. It would be an inconsistent verdict if, for instance, if they found armed robbery, no armed robbery, but also found quid. That would be an inconsistent
But
verdict.
it's still
Also-
evidence, right? Isn't it? Is it the case that we can look at the jury's verdict and say, well, they acquitted of this, or they asked some jury questions about that, they were troubled about that, and have that enter into the sufficiency analysis? I mean, there is evidence in the record that the complaining witness saw a gun. It may not have gone over very well with the jury, but there's also evidence that this man was sitting right next to him and asking him to hand over things one by one. It seems, do you have authority for just checking, removing the testimony about the gun from the sufficiency analysis?
I'm sorry, could you ask that last
Yeah,
question?
do you have authority that we would remove, any consideration of the gun, the testimony about the gun, any evidence about the gun, just because of what happened in the verdict? It's hard to know, what juries made of certain evidence.
Well, I think it's relevant. The jury unanimously agreed that the jury unanimously agreed that he was not guilty of quid, not guilty of armed robbery. So what I'm going to argue is that, from a subjective standpoint, if we're looking subjectively, he thought he saw the barrel of a gun, but the jury made an objective determination. And the test is objective, not subjective. And, so, the fact that he said that there was something, perhaps, but, the fact that the jury took that basically out of the equation, and what you're left with.
Well, the judge's question is, the jury wasn't persuaded by that to find guilt of armed robbery. That's for sure true. But your opponent cites case law that says that doesn't take it out of the equation, to use your formulation, for our purposes when we're trying to figure out whether the guilty verdict the jury did return is supported by evidence. And that's the difficulty, is that there are these cases that say whatever the jury's verdicts on other counts might have been, if there's a count of conviction, then the Court of Appeals, the appellate court, is supposed to look at all of the evidence, even that goes to matters that the jury seemed to have acquitted on, in assessing whether the evidence was sufficient to support the guilty verdict. And that for me, that makes your argument a difficult one.
Well, but in this case, he didn't say he saw a gun. He said he thought he saw what was the barrel of a gun. That, he didn't see Kelly make a gesture or even afterwards. And the fact of the matter is that, there was nothing that directed the complainant to look down. Kelly didn't tell him look down. He looked down and he thought he saw the barrel of a gun. But that doesn't mean that there actually was a gun there. So, in this particular case, we're not, we're dealing with what looked like the barrel of a gun versus actually seeing a gun, and then the jury saying, well, we don't think that there was a gun.
Ms. Daniels, let me clarify. I take it you agree that there could be a robbery, force, or violence unarmed. So your argument seems to hinge on the use of the term ask.
Well, Yeah, yes. I mean, whether or not the conduct was menacing enough to create a reasonable apprehension of danger. And so in the Williams case, which I know Your Honor kind of reluctantly concurred in, if I would compare it to that case, where Williams, you're in a metro by an elevator at night, no one's around, with 3 people. In this case, you're during the day, you're in the 4th row of a crowded train. So, and in Williams said, when a person parts, for instance, with money upon a mere demand, made in a rough, positive voice with an oath, the taking is not a robbery. So we would rely on Williams and say, for instance, Gray is very different. There was so much more. But in this case, there was an asking, there wasn't even any swearing apparently. And the complainant himself said that the only reason he gave over his possessions to begin with was because he thought he saw the barrel of a gun. There was absolutely nothing else in the conduct that caused him to be fearful. When the government said to him, "How were you feeling at the time?" he said, "Upset emotionally." "Why did you give him your stuff?" Because he thought he saw the barrel of a gun. So it really is limited in this case to what, even from his own mouth, what caused him to be fearful was only that he thought he saw the barrel of a gun, that Kelly did not direct him to or say, "Hey, look down here," or "Look what I've got," or anything like that. So there was no gesture or menacing conduct. So we would ask that the court reverse his conviction, and in the alternative, grant a new trial.
Thank you very much, Ms. Daniels. Ms. Ament, thank you for your patience, and we'll hear from you now.
Thank you, Your Honor. And may it please the court, Christina Ament on behalf of the United States. And if the court please, I'll begin with the territorial jurisdiction issue. And I would just ask the court to step back for a moment from the arguments that we've heard this morning and remember what this court is being asked to do. In this case, the trial judge was called upon, was asked to give a jury instruction and applied 30 years of this court's precedent and determined the procedure to handle this, and determined that that didn't include giving a jury instruction on the issue of territorial jurisdiction. Instead, the court considered this as a matter of law, as this court's decisions had directed it to do. And this court's decisions, I might add, that were based on the same statute the council was arguing about jurisdiction and what Congress's authority was in DC. So it isn't like the trial court wasn't aware of the basis for its authority or the basis for the court's jurisdiction. And what the trial court did was consider the arguments and say, there isn't any evidence to suggest that some element of this crime didn't occur in DC, and therefore there's nothing to instruct the jury about. And we would submit that that decision is correct under the court's case law, and that appellant has not shown that the Apprendi line clearly undermines that to the degree that this panel can consider Adair and its progeny to be overruled. Given that, we would suggest that there was no error in the trial court's approach here and the trial court's finding that territorial jurisdiction existed. Even if this court were to find such error under the Apprendi line, we would submit that that error was obviously harmless, because essentially, as this court noted in discussing the two related concepts of jurisdiction, the defendant here was whipsawed. He wasn't going to be able to raise a genuine issue of territorial jurisdiction because either the robbery took place, or aspect of the robbery took place in DC, that would be the asportation element, or the robbery took place in Maryland and appellant brought the loot from the robbery into DC as was testified about, he subsequently gave that to his girlfriend in DC after the two of them had left the Metro at Congress Heights. And we would submit that given that a properly instructed jury would have heard about both of those aspects of territorial jurisdiction, there was no way that a reasonable jury, properly instructed, would have found or would have failed to find territorial jurisdiction. And that's the way that the Supreme Court is directed to approach this type of Apprendi jury instructional error. So again, no error in the trial court's approach, and any error that this court might find is harmless beyond a reasonable doubt. Turning, if I might, then to the second issue, if the court has no questions on jurisdiction, turning, if I might, to the second question of whether there was a Fourth Amendment violation here, we would submit that that the trial court properly denied the motion to suppress because there was no search within the Fourth Amendment, given the limited nature of what Metro Transit Police did in tracking this card. And first of all, if we might sort of like look at how the Metro cards work, or how they used it in this case, what the transit police did was, first of all, to listen to the report of a robbery and then go back and look at surveillance videotape to determine whether somebody matching the description had left the Metro at Congress Heights. And once that had taken place, they were able to use the Metro's records to determine which Metro card had left Congress Heights and put that card on a tracking list to find out whether that person returned. In addition, given the fact that they now had a photograph of appellant, they also put out a flyer, a BOLO flyer, for people to be on the lookout for him specifically. And the next day, as a result of the use of that limited tracking use, they were able to find out that appellant had entered the Gallery Place Metro and stop him, coincidentally, along with his girlfriend, and saw stolen property in her possession and sees that as evidence in this case.
Ms. Ament, I think I heard you say there was no search. Could you expand on that?
Yes, Your Honor. Basically,
why not? Are you relying on the third party doctrine, or why was this not a search?
Well, first of all, it's not, we are relying on the third party doctrine, which clearly applies in this case, and which there's no authority in this court to suggest that it is no longer viable in a situation like this. Because basically, in this case, what appellant did by using his Metro card was voluntarily tell Metro, as you, Judge Fisher, mentioned earlier, he put his card on a card reader, told Metro where he was entering the Metro, and then completed his transaction by telling Metro where he was exiting the rail system in order for them to decide how much to pay. And then there's no reasonable expectation of privacy in that information. Everybody knows that that's how your Metro card is charged in the Metro. And not only that, but given the extremely limited nature of the information that was looked at in Metro records in this case, as was mentioned in the Massachusetts case, and the Supreme Court talks about in Carpenter, there are times when people can look at data like this, and it just simply isn't enough to rise to the level of a Fourth Amendment search. So under the third party doctrine, or the concept of a search broadly, there simply wasn't one here.
Do you have any thoughts about how much is too much? You have the Carpenter cell phone case, which talks about 24/7 tracking of someone's location. You have facts like this, which you're arguing are not enough to be a search. As I understood the detective's testimony, he got a printout that showed Kelly's movements for probably a 2-day period. Why isn't that enough?
Your Honor, basically, if we take cell phones out. If we look at what made the court in Carpenter say that cell phones, or what the court in Jones said about GPS tracking, is basically that's a 24/7 way to track somebody's movements, at least within feet. I think I don't know how accurate cell site data information is at this point. I've read about it, but I think that my information might be old. But it basically gives, you could draw breadcrumbs with somebody's cell site data and figure out where they went. If you track their data for a day, for example, you would know where they went just about everywhere in a day, unless they either put a Faraday cage on their phone, turned it off, or went in somewhere where there was no cell phone service. In the Antoine Jones case, they were able to track every single place that somebody went in his car. Here, by contrast, the information about where somebody's whereabouts is at any given moment is simply not even detailed enough for you to figure it out. For example, when somebody swipes their Metro card onto the card reader, it registers that they are at that card reader at that moment, but there's no tracking beyond that. Once that card is more than 2 inches away from the reader, we don't know where somebody went. Somebody could swipe their card on that card reader and just leave the station. Or go at Gallery Place, which was one of the Metro stations where they tracked him, where they tracked his card to, is a huge station. There are many exits and egresses. There are many different train lines. There's no way that you could draw anything like breadcrumbs from using somebody's whereabouts on a Metro, using their Metro card data, and that's it. And even if we look at broadly what the court in Massachusetts was doing and talking about mosaics, in other words, aggregating all the data you could put together from several different times of looking at where somebody's Metro card reader is, we would submit that far from a mosaic, we have a couple of tiles, and some of them are probably chipped or faded in color as far as figuring out in real time where somebody is, or making a retrospective tracking of where they went.
But isn't it right,
doing,
Ms. Amen, isn't it the case that it's not just, someone's wandering around the Gallery Place metro station somewhere, but you see where they've traveled?
It's possible that you could see generally where they've traveled to, Your Honor, but basically, even if you saw that they traveled from one station and then they saw that there was an exit to another station, that's hardly the detailed profile of life that the Supreme Court talks about in Carpenter and Antoine Jones. It's discrete data points that somebody has offered up to Metro in order to take the trip. Has told Metro, it's fine with me that you know where my card reader is, and it's fine with me that you know where I get off, because otherwise I couldn't actually pay for my trips in any way. It's
but again,
just like,
isn't it relevant the purpose for which we think that use is going to be made?
Your Honor, I would submit that that the purpose might be relevant, but the degree of intrusion here is so minor that even if the purpose is to detect crime, everybody knows that that Metro security can access this kind of thing, and in fact, customers realize that Metro station managers can access it in case somebody needs to get out and their card isn't working on the card reader. So
how much
there
is your,
are
obviously that people are aware isn't enough, because people are probably aware that the cell phone is, creating in the hands of third parties vast amount of information on what people are doing. But how much does your argument depend on kind of the granular and sporadic nature of this, and how much on kind of duration and quantity? Is it your view that, let's say that the police develop somebody as a suspect in an ongoing investigation, and they decide, we know the person used Metro, we're going to figure out what Metro card, we'll tail the person, find out where the person uses a Metro card, a smart card at a Metro station, get that number, put them in a tracking thing, follow them for 6 months while our investigation is going on, and then we can try to, who knows, coordinate with other people smart card trips. And
would that all be no search in your view, no matter, even for a much more substantial duration, because all you're learning about is kind of station, entered station A, exited station B information? Or do you think that there would come a time where even that granular information would be sufficiently intrusive as to amount to a search?
Your Honor, I wouldn't go so far as to say that there could never be a time when using the metro tracking couldn't become pervasive enough. But even if there could, this is not that case. This is a case where somebody voluntarily used a card, let Metro know what their card number was, and it was tracked for one day for them to locate where he went again. And they weren't able to develop any type of profile about him or his life or any kind of information that was aggregated.
Is it right that he was tracked for only one day? I thought he didn't they use his card also to arrest him some days later? And I'm not entirely sure what evidence other than the card itself was recovered at the time of his arrest. But am I misrecollecting? Was his card, the tracking of his smart card, also a component of their ability to arrest him on the date of arrest, which I thought was more in the nature of a week later or something, or maybe more than that?
Your Honor, I believe it was October 27th. It was less than a week later, and I don't actually know. That's what Ms. Daniels said, and I'm not saying she's wrong, but I'm saying I don't know where that appears in the record because nobody put any evidence in about this at trial. I don't know how they found him to serve the arrest warrant on him. In other words, after they had stopped him on October 28th, the police got a warrant for his arrest, and he was located and arrested in D.C. several days later. But he was arrested someplace on Georgia Avenue, and nothing that I found in the record specifically says that the Metro card was used for that purpose.
Ms. Ament, there's another aspect to this that we haven't talked about yet, which is the tracking list. That is, the detective put this card on a list and arranged that he would be notified the next time that Kelly entered the Metro system. Does that change the analysis?
I don't think so, Your Honor, because once again, if we look at the fact that this is third-party data again, so the third-party doctrine applies to that just as it would in any other situation where someone is voluntarily giving their information to Metro. And once again, even if the third-party doctrine weren't in effect, which we submit it was, we still are left with the very minimal idea that that a company was able to notify its own security personnel, its own employees, that somebody's payment card had been used one day later. That the tracking list was not used in this case to generate any of the kind of intrusive profiles that were criticized in Jones and Carpenter. Instead, it was used to locate a card, where a card was on any given day, so that somebody might be able to find out who was using it. And we would submit that the tracking list, just like the number of the Metro card involved here, were simply not the kind of intrusions that that violated somebody's reasonable expectation of privacy. And to the point that Ms. Daniels also mentioned that he would have had no way of knowing that anybody would have access to this, but it says right on his card that he is required to show it to Metro personnel at any point. So he's not under any illusion that somehow his card is super secret information that nobody would have entitlement to. Anybody could have asked him for that card in the Metro at any time to determine what the number of it was. And basically the card reader and the tracking list just did that. What his card advised him he was on notice to have to do. If there are no further questions, we would ask that the judgment here be affirmed, and thank the court for its time.
Thank you, Ms. Ament. Mr. Collins, we'll give you 3 minutes for rebuttal, and we'll stick to it this time.
Thank you, Your Honor. I would start with the correction, which is that I concluded on saying that jurisdiction should be a structural error. The jury's failure to find jurisdiction should be a structural error, or that at least would be consistent with federal practice. That's not correct. Green versus United States, which is a case of this court, and Godin versus United States, which is a case of the Supreme Court, both state pretty clearly that the failure to find an element by the jury is subject to harmless error review. We don't think there's anything about the unwaivable nature of jurisdiction that would change this analysis, and we aren't contending that this is not subject to harmless error review in this case. Obviously, the court has asked for briefing on that question, and we didn't respond with any kind of structural error argument. So we don't think it's not a necessary implication of the argument we made, and it's not necessary to conclude that geographic jurisdiction is an element or is its functional equivalent such that it requires a jury determination. And
would the plain error test apply if the defense did not request that instruction?
I think so. I don't see why not, at least.
Well, one might argue that the principles of plain error arise only when you had an obligation to make an objection and failed to do so. And I'm still confused about whether you think the defense has to raise this question in order to get the instruction.
So I think the court has some leeway there in terms of determining, consistent with our argument, this is an element of the offense, and this, when you request an instruction on the offense, you request, or when you give the instruction on the offense, it's understood that it also needs to be included an instruction that the jury has to find that at least one element occurred within the District of Columbia. So I guess as to the question whether defense counsel have an obligation to request an instruction on jurisdiction specifically, separate from the rest, we're more or less agnostic. We haven't taken any kind of position. We could see arguments on either side. And segueing, I think the question whether the jury has to be instructed in every single case, or whether it's just it's more like a defense, which Judge McLeese has mentioned. We see case law on both sides that would support both conclusions, and because there is precedent going either way, I think the court has some leeway there, and so we would defer to the court. But ultimately, our position is, and if there are no further questions, we ask the court to rule that Adair versus United States has been substantially undermined.
Thank you, Mr. Collins. Ms. Daniels will give you 3 minutes as well if you need them.
Okay, thank you. First of all, the third party doctrine was brought up. Henley said that there is no third party doctrine. They analyzed that when they said it's used to pay for public transportation. So I direct the court to that analysis. Also, just to mention that the testimony at trial from the Metro record keeper, whoever that person was, they testified that they believe that they do need a warrant if the card is registered. It's just that, but in this case, the card wasn't registered. So at least Metro itself, I just want to point out that Metro itself recognizes that there is a privacy interest here. And Ms. Ament spoke about the second stop and upon arrest. It is unclear whether or not they actually used his card for that purpose, but we do know that he was arrested right outside of a metro. And the other thing I want to mention about the jurisdiction is, in a very broad perspective at least, that it does affect punishment, from the perspective of, if the crime occurred in one jurisdiction versus another, the different jurisdictions may have different penalties for the crime. And so it could actually affect someone's punishment depending upon where they're prosecuted. And finally, I just want to say that with respect to the sufficiency of evidence issue, that there's even more reason in this case than in Williams to find insufficient evidence. And I thank the court for its time today.
Thank you very much, Ms. Daniels and Ms. Ament, for your briefs and your arguments today. And thanks, Mr. Collins, for your amicus help today. We will take this case under advisement, and the court is adjourned.
This honorable court is now adjourned.